ಏನು ಮಾಡಬಾರ್ದು. ಓಕೆ.
ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸಾಹೇಬ್. ಸೋಮೆಟ್ರ 15 ಇದೆ. ಇದೊಂದೇನಾ? Submission, my lord. Submission, my lord.
We'll call out adjournment to first, page wise. After that, your submission.
Page wise. Page 10, admission matter 52 to 58. Page 11, 59 to 63.
My lord, serial number 62, my lord. A week accommodation, my lord. I appear for appellant. A week time will be granted, my lord.
Request of non-counsel for apparent, relist next week. All right, at request of non-counsel appearing for respondent number 1, relist after 3 weeks. Inform Mr. Gurudev. He's here.
Page 12, 64 to 66.
At request of non-counsel correspondent number 1, released after 2 weeks. Inform Mr. Krishna Swami. Inform Mr. Krishna Swami. When is the attachment warrant ordered? When is the case now? Insurance company. When do you want it? When do you want it, sir? Tomorrow I may not be sitting tomorrow. Have it on Monday. This is at ECA, na? ಬಂದಿಲ್ವಾ ರಿಸ್ಟ್ ಆಗಿಲ್ಲ
ಅವಾರ್ಡ್ ಇರೋದು 6,72,000 ಡಿಪಾಸಿಟ್ ಮಾಡೋದು 6,72,000 ಸಿಂಪ್ಲಿ ಅವಾರ್ಡ್ ಇದೆ ಅಮೌಂಟ್ ಆಲ್ಸೋ ರಿಪೀಟೆಡ್
get this matter Kodi we'll see get this matter by 1:30 you come by 1:30
Fresh matters, serial number 1, Chetan BR.
Chetan BR serial number 1 to 6 issue notice to respondent.
Serial number 7.
If I appear for the appellants, my lord, appeal by the KSRTC, my lord. The appeal is the order of the MSCT is challenged on the ground of negligence and quantum of compensation that is awarded. The MVC is filed after a delay of 7 years, my lord, from the date of accident. And the income that is taken by the honorable tribunal is on the higher side, my lord. As per the local adalat, 6,500 had to be taken, my lord. Honorable tribunal has taken the income at 7,500, my lord. And the two major children are considered as dependents, my lord.
What is the law on that point?
My lord, the major two children, my lords, are aged.
All right, you deposit heard Leonard Counsel Sri Shankar Gaud
Please.
appearing on representing the appellant corporation. Issue notice to respondents. Orders on IA 1 of 22. There shall be stay of the judgment and award dated 22/9/2021 passed by the MAC2 Bengaluru in MVC 4083, subject to the condition that the appellant deposits 50% of the award amount within a period of 4 for this court.
Please.
Serial number L. Srikandara.
Liability. Really? Is 1817. Third, Learned Counsel Sri L. Srikantara for appellant insurer. He submits another appeal has been filed in MFA 1827 of 2022. By whom? By the insurance company, the connected claim petition. Full stop. Issue notice to the respondents. Huh? Howdo, that's correct. Issue notice to respondents. Orders on IA, there shall be stay of judgment and award passed in MVC 5858 of 2019 dated 20/11/2021. The file of small causes, Chief Judge Small Causes, member MACT, subject to the condition that the appellant herein deposits 50% of the award amount. Madam, before the orders on IA, 1827, the registry to list this matter along with MFA 1827 of 2022. ಇದು ನಿಕಡತಲ್.
Serial number 9.
Yes. No liability. Notice to respondents number 2 and 3 is dispensed with at risk of appellant. Issue notice to respondent number 1. For 10 to 15. Oh, 14. K. Suresh. Suresha K. No representation, list next week. Next matter, issue notice to respondent.
Serial number 14, my lord.
ಅರ್ಧಕ್ಕೆ ಇರೋದೇ ಇಲ್ವಲ್ರಿ ನೀವು ಮಿಸ್ಟರ್ ಸುರೇಶ್?
Serial, I am here, my lord. Serial number 14. Sorry, my lord.
You have to run along with us.
Sorry,
You
my
can't
lord.
come behind. ಹೇಳಿ.
On the insurer's appeal, on the ground of quantum and liability, my lord.
What is the liability? What is the liability?
Yes, my lord. It's a pedestrian, my lord. He was crossing the road, and in the middle of the road, the accident has happened. He has contributed for the negligence, my lord. He was not taken the case. He did not cross the road where he has to cross.
You notice to respondents. There shall be stay,
50% of the amount.
judgment and award. Dated 12/11/2021, passed in MVC 452 of 2016 by Senior Civil Judge and JMFC at Tiptur, subject to the condition that the appellant deposit 50% of the award amount within a period of 4 weeks before this court.
Alright, serial number 16, Gopala Krishnamurthy.
Got it. What's your name? Kumari Maneta. Manasa. Learned Counsel Shri Kumari Manasa on behalf of Shri Gopala Krishnamurthy, representing the appellant, files a memo seeking withdrawal of this appeal on the ground that the matter has been settled out of court. Settled in Lok Adalat. Hence, memos placed on record, submission taken on record. Appeal is dismissed as having been settled before the Lok Adalat.
Serial number 17, Mahadev Swami, please.
Notice to respondent number 2 dispensed with. IA1 allowed. Delay of 142 days condoned. Yes?
74 10 of 19.
74?
10 of 19.
10 of 19. Registry to list this matter along with MFA 74 10 of 19.
Serial number 18, Manjunath MD.
Reliance. Patel Reneva. Yes, Learned Counsel Sri Ashokin Patel accepts notice on behalf of respondent number 3. The notice respondent number 1 and 2 is dispensed with at risk of appellant. IA allow madavada? IA number 1 allowed delay of 325 days in filing the appeal is condoned. However, on appellant being successful, shall not be entitled for interest for the delayed period. Learned Counsel for the Atkin Munchema before the orders of IA. Learned Counsel for the appellant to furnish one set of copy of the appeal along with the impugned judgment award. The Learned Counsel correspondent number 3.
Number 19, R. Shashidhara.
Notice to R1 and R2 dispense with the risk of appellant. You are the owner. Who are you? Claimant.
Another ready for all three.
Shashidhara. Release this matter next week. Same order next matter also. Huh? 20? Your Krishna Kishore. Delhi Shashidhara. Delay condemn madada.
I appeal for second respondent. Delay may be controlled, my lord. No
Who are you?
objection. AP for second respondent, insurer.
Aitala adu.
Yes, ma'am.
All right. Notice to respondent number 1, Madam 20 ali. Notice to R1 dispense, delay, I allowed, delay condoned. Yes, next matters also same. R1 dispensed, IA1 allowed, delay of 198 days condoned. However, appellant on being successful shall not be entitled for the interest due for the delayed period.
Serial number 22, Rangegaoda NR.
AP for appellant, my lord.
Ah.
Memo for presentation of notice to R1, my lord.
No liability.
No liability, my lord.
Notice to R1 dispensed.
TCR may be called for, my lord.
Registry to secure trial court record, TCR.
Serial number 23, Ravi Shankar Shastriji.
My lord, I sought for dispensation of notice to R1, my lord, no liability.
Notice to R1 dispensed.
But 81 days
IA1 of 19 allowed, 81 days delay condoned.
TCR may be required, my lord.
TCR, registry to secure TCR.
Serial number 24, Dr. Suresh.
Memo for dispensation R1 R2 allowed at request at the risk of appellant.
Serial number 25, Guru Prasad PR.
National Insurance Company. Ashok.
My lord, I am there in the National Insurance Company, my lord. I'll take the notice.
All right. Yes, what is your name? You are there on record in the panel? National Insurance Company? All right. K. Sridhara. Learned Counsel Sri K. Sridhara, who is present before the court, accepts notice on behalf of R1. Learned Counsel for the appellant to furnish one set of copy along with the impugned judgment and award. Memo to R2. No liability? Dispense with. IA1 of 2021 allowed. Delay of 275 days is condoned. However, an appellant being successful shall not be entitled for interest for the delayed period. Register trial court records. Madam Nirmala,
My lord, we have already deposited the amount in serial number 29, my lord.
25 ಅಲ್ಲಿ K. Sridhara is being directed.
ಆಯ್ತು ಸ್ವಾಮಿ. ತಾವ್ ಹೆಂಗ್
ಏನ್
ಹೇಳಿದ್ರೆ
ತೊಂದ್ರೆ ಇಲ್ಲ. ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಅಲ್ಲ. ನೀವು ಬೇಜಾರ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಕಷ್ಟ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ಏನ್ ಡಿಸ್ಕಷನ್, ಐ ಲೀವ್ ಇಟ್ ಟು ದಿ ಆನರಬಲ್ ಕೋರ್ಟ್.
The discretion is on like this. The discretion is like this. If learned counsel is present in the court physically, gets the first preference.
Fine, my lord, fine. He is also my colleague and friend, my lord. Absolutely
yes.
no issue.
Good spirit.
Serial number 26, Emi Mahesharappa.
ಏನ್ ಥರ್ಡ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆಯಲ್ರಿ, ಅದು ಎಷ್ಟೊತ್ತಾಗತ್ತೆ? ನೀವೇ ಕೂತ್ಕೊಂಡು ಮಾಡಿದ್ರು ಒಂದ್ ಅರ್ಧ ದಿನದಲ್ಲಿ ಮುಗ್ದೋಗುತ್ತೆ. ಹಾ, week's time granted for doing the compliance.
Appealing for the appellant in this case, my lord. R3 is the owner of the vehicle, my lord. There is no policy of insurance as on the date of accident, my lord. I will take steps to R3, my lord.
Huh?
They have filed the insurance company and filed the appeal. They have deposited 50% of that needs to be released.
All right.
They also filed a memo.
What is the non-compliance? Who else has to be served?
They are
Notice. Who are you? You are claimant. Claimant already. Pradeep.
Please, my lord.
Any further service of notice?
R2 is the owner of the vehicle, my lord. R3 is also owner of the vehicle. Some of the cases where R2 is served. My lord, R3 is not served, my lord. R3 is very much required in this case, my lord. The remaining 50% has already been done by the claimants, my lord. Only 50% we are challenging before this honorable court. Remaining 50% we have not had challenged, my lord. 2 vehicles were involved in the accident, my lord. 2 tempo travelers. One tempo traveler having insurance, my lord. As
what is the complaint saying?
Valid.
2 weeks time granted to do the compliance. Notice to R. What about notice to R2 and 3? Okay. If PF paid and if needful is done, registry to issue notice to respondent number 2 and 3, or only 3?
3, my lord, in connected matters, my lord. One case, my lord, R2 is not served. Another, my lord, 27.3 and 4, R2 is served, my lord.
All right. So issue notice to R3.
Please, my lord.
No more the appeal had been filed in the same last date. We mainly connected.
Filed by whom?
Filed by insurance company.
Insurance. You have filed 2 more appeals.
Please, my lord. Please, my lord.
90?
9367 and 9368 or 18.
Registry is directed to list MFA 9367 and 9368 of 2018 along with these appeals. No, you have filed for release, alva? 50% ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. What
50%, my lord, here, my lord, 1 and 4 are equally responsible for the accident. Both are insured with the Reliance General Insurance Company, my lord. Remaining 50% we have not at all challenged, my lord. Only 50% we are challenging before this honorable court, saying that, my lord, there is no policy of insurance, particulars also not mentioned in the claim petition, my lord.
All right, we'll consider, let them come before the court. Yes, sir. Krishna Swami. Non-deposit 50% before this court. IA1 for delay. Sridhar. Now representation on behalf of appellant released next week. You claimant ga amount deposit madilla avaru. Nirmala madam.
My lord, we have already deposited on 19/2/21, my lord. I'll produce the memo before the counter, my lord. And also I'll pay the process for the second time.
Learned counsel for the appellant submits that she has already deposited the amount as ordered by this court on
19/2/21, my lord.
19/2/21. Same is placed on record. If PF is paid, registry to issue notice to respondent.
Second time.
Sole respondent?
Only one respondent, my lord. Only one respondent.
Respondent.
Much obliged.
Within 1 week, if notice is, if PF is paid within 1 week, notice to. Sitaram Rao, Anup.
For stay in this matter, Malad, no policy, no liability.
No policy?
No liability.
No liability on insurer.
Despite that, I've made liable. No insurance policy is produced, no particular, nothing. Despite that, MACT fastens liability on the insurance company.
All right. And what is the basis of liability being fixed on you then?
On an assumption, adverse inference is drawn, Malad. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿನ ಪಾರ್ಟಿ ಮಾಡಿದ ತಕ್ಷಣ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯವರು ಹುಡುಕೊಂಡು ಬಂದು ಇನ್ಶೂರೆನ್ಸ್ ಇತ್ತಾ ಇಲ್ವಾ ಅಂತ ನಾವು ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಿತ್ತಂತೆ. ದಟ್ ಈಸ್ ಇಂಪಾಸಿಬಲ್. ದೇರ್ ಆರ್ ಸೆವರಲ್ judges of this court and the Supreme Court which is insurer cannot be asked to produce the insurance policy. Policy particulars has to be produced by the insured. In fact, this case was filed against HDFC Ergo Company. And later HDFC are going to delete ಮಾಡ್ತಾರೆ, ಇವ್ರನ್ನ include ಮಾಡ್ತಾರೆ. Our policy particulars ಇಲ್ಲ, your policy particulars ಇಲ್ಲ. We have filed a memo before the MACT saying we have not insured this vehicle. Despite that, I am made liable to pay.
What vehicle is it?
ಹೌದು, ಮಾರುತಿ ಕಾರ್.
Order. Learned counsels. The Anup Sitaram Rao for appellant. Issue notice to respondents.
ಆಗಿದೆ, ನೋಟಿಸ್ ಇಸ್ ಆಲ್ರೆಡಿ
await ಆಗಿದೆ. ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ. ಏನಾಗಿದೆ? ವಾಟ್ ಹ್ಯಾಪನ್? await ಇನ್ನೂ ಅದೇನು ಸರ್ವ್ ಆಗಿದೆ. await ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್. Orders on IA1 2022. There shall be stay of judgment and award. Dated 17/10/2020 in MVC 28 of 2017. Passed by the senior civil judge JMFC and MACT NR Pura, subject to the condition that the appellant deposits 50% of the award amount before this court within a period of 4 weeks.
That's obliged.
Number 31, Sri Asha AK.
Harsha. No representation released after 2 weeks. 2 weeks time granted to do the needful. You made a note. Why was it dismissed? Learned counsel for the appellant submits that he has made a note in the just below the first title that the respondent number 3 respondent number 3, the claim petition against respondent number 3 came to be dismissed by the trial court. Hence, he is not made a party before this court in the present appeal. Submission of the learned counsel and the note is sufficient to is accepted. The objection raised by the registry is not sustainable, hence overruled. Issue notice, yarge both 1 and 2. Issue notice to respondents. Your claimant, all the one claimant appeal, one insurer. New claimant ga? No, one is filed by him.
Another one is also there.
664 is filed by you. It's filed by insurer. Who are you? All right, we'll condone the delay. With a substitute service, yarge. It's not pressed. IA number 1. First matter. So PB Raju is given NOC. Ravi Shankar, PB Raju has given NOC to you. So we can delete the name of heard learned counsel for the appellant. In view of the fact that learned counsel Sri C.R. Ravi Shankar has filed wakalat on behalf of respondent number 2, registry is directed not to show the name of learned counsel Sri P.B. Raju as counsel for respondent number 2. Full stop. Orders on IA1 up to 2019. IA1 allowed. Delay of 98 days is condoned in filing the appeal. Next matter. Third, learned counsel Sri C.R. Ravi Shankar for the appellant insurer. IA1 of orders on IA1 of 2021. 19, IA1 of 19 is allowed. Delay of 37 days in filing the appeal is condoned. Orders on IA1 of 21. This application is filed for substituted service to be taken to R2, whereas R2 has already filed wakalat, hence the same is dismissed as not pressed. Release of amount. Nimdena liability ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ on 50%. Total amount is to 50% you take. No, now you are challenging the liability. The liability you are trying to shift it on the owner. So even if the liability we fix it on the owner, you still have to pay and recover. You have already deposited 50%. You can withdraw 50%. Barkoli. Orders on IA-1 of 2022. This application is filed by the claimant. Claimant. Injury. By the claimant for release of amount deposited by the insurer. It is the insurer has already deposited 50% of the award amount, though the insurer has challenged the liability which is fixed on him to be fastened on the owner. However, the same would be subject to the outcome of this appeal as well as subject to the judgment of the Honorable Apex Court with regard to pay and recover. In view of the same, claimant is entitled for release of 50% of the amount deposited by the insurer. Registry to release, deposit madidira? Registry to release 50% of the amount in favor of the claimant upon proper verification as per the award amount. 50% of the only one person. Huh? Yes. What is next? Next. 34.2 ಅಲ್ಲಿ ಅವ್ರದ್ದು ಅಲೋ ಮಾಡ್ಬೇಕು. ಯಾರು? ಇಲ್ರಿ ರವಿಶಂಕರ್ ನೀವೇ ಅಲ್ವಾ 34.2 ಅಲ್ಲಿ you're the appellant. Correct. Before that 34.2 is your appeal. IA2 for delay is allowed. 32 days in filing the appeal is condoned. Next is 2280. ಇದರಲ್ಲಿ ಇವಾಗ ನೀವು your notice ಆಗಿದೆ ತಗೋಬೇಕು. Learned counsel for appellant. Learned counsel Sri C.R. Ravishankar, who has already filed the other two appeals and on record in the connected appeals, accepts notice on behalf of respondent number 2. Or idarala already on record. Hence, no need of notice to be taken in respect of respondent number 2. Release this matter for admission. 2 weeks. 2 weeks.
Number 35.
I am appearing for the appellant. This is insurance appeal on quantum.
Application
for withdrawal. Yes.
It could be disposed of. Case itself could be disposed of, my lord. I am ready, my lord. ಅದು ನಾ ಬರೀ ಕ್ವಾಂಟಮ್ ಇಂಟ್ರೆಸ್ಟ್ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್.
What is the year of MVC case? 15. All right. So you are ready. Both of you are ready.
I am ready, my lord.
All right. We'll call it after the first round.
Sorry, Swami.
Shastri ji.
283 delay in filing the appeal, my lord.
Heard learned counsel for the appellant and the respondent. IA orders on IA number 1 of 19. IA1 allowed. Delay of 283 days is condoned. However, an appellant being successful shall not be entitled to interest for the delayed period.
My lord, the insurer had filed MFA 7401 of 2018, my lord. It may be called
to list this matter. List MFA 7401 of 2018 along with this appeal, which is preferred by the insurer.
Number 37, Manjunath MD.
Issue notice to respondent.
Number 38, Ravishankar CR.
Cannot be released because he is traveling in a tractor. As per the full court has already going to go left in the insurance.
He is traveling in the
Tractor. challenge ಮಾಡಿದ್ದಾರೆ ಸರ್
is from background. Whatever Indian she has separate tractor. She has not.
All right, what is this connected appeal cross objection? Oh, new. This is a death case. Death case.
ನನಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲ ಅವರಿಗೂ ಮಾಡಿದ್ರು ಈಗ ನನಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಓನರಿಗೆ ಸರ್ವಿಸ್ ಮಾಡಿ
R. Vijay Kumara for owner. So service is complete. All right. Perkoli in MFA CROB 35. IA1 of the orders on IA1. IA1 is allowed. Delay of 79 days in filing the appeal is condoned. Both these appeals be listed for admission after 2 weeks. Get ready. Registry to secure the trial court records.
5/3/2020 she has lost her husband because she has lost her only son. He is in very pathetic condition. The least what will happen is the insurance company will not have owner. He is in very pathetic condition. He is not already
Against whom? So deposit is made by whom? You have deposited amount. Right, Mr. Counsel. Now, if we hear the matter, the court hears the matter, and if we are in agreement with him, the liability will shift to the owner. He will have to pay. He is already deposited. So we have to satisfy the court. So come after 1 week or next. When do you want it? Next week? No. The other person is not here. Maybe, sir. How can I dispose of the matter without hearing him? How can we release this amount when he says there's no liability? He has to be given an opportunity of being heard. No, we understand the situation. Sympathetically, we can only say that it can advance the matter from 2 weeks to 1 week. Release this matter next week. Next week date, whichever you want, you take. Elin Barbeku. Let it come. Released on 25th, 24th. 25th, registry to secure trial courts records by then. 29th, all right, 29th. Issue notice to respondent in both 39 and 40. Issue notice to respondent.
41, Keshav Prashant.
You're for? You filed the IA. Where is the appellant? Keshav Prashant.
Keshav Prashant.
Orders heard, learned counsel for the appellant as well for the respondents. Orders on IA 1 of 21. IA is dismissed as not pressed in view of the appeal being in time. So you have filed LR application to bring legal representatives of R1 as 1A and 1B. All right. Any objection? No, he has to say whether he has any objection. Release this matter next week.
Number 42, Sridhara K.
Deposited the amount before the NSCT.
3%. Lord counsel for the appellant files a memo furnishing details of deposit of the amount as ordered by this court before the MACT. Same is placed on record. Yaru Nagaraj Egade, ready na nivu? Release this matter next. What? 48? Registry to list MFA 4825 of 2020 along with this matter. Relist after 2 weeks.
Number 43, Ashok M. Patel.
Dispensation yarge. Dispensation yarge Patel. But madam, you have to see for dispensation for whom. See it, madam. Judgment copy. You produced. Idea. All right. Dispense IE1 of 2020 allowed as the certified copy of the judgment and award is already produced in the connected matter in MFA 287 of 2021, which is arising out of the very same accident, very same impugned award, judgment and award. All right, 50%. Heard orders on IE1 of 2021. Who's for the claimant? Manjunath. Manjunath Kandekar. Barkoli. IF1 of 2021 is allowed. The claimants are entitled for release of the amount, 50% of the amount deposited by the insurer. Registry is directed to release 50% of the amount deposited by the insurer, subject to proper verification. What is the next matter? Same order in the next matter. The amount in deposit before this court is to be transmitted to MACT, concerned MACT. Yes, that's all. Yes, next. You're challenging the quantum and negligence. On the basis of contributor negligence on?
They have come and hit from behind. Now, this is the bachelor. Interest is awarded 9%.
Registry to secure trial court records.
Number 44, PP Siddaramaiah.
Yes. Income? Which year matter is the MVC? 18. You're ready? Whichever date, both of the choose 28, 29, 31st. All right. Release at request, release this matter on 31st. Huh? Request of respondent R1 released on 31st. Next.
Number 45, PP Siddaramaiah.
Hard to find this. During the COVID situation, they are not able to do the
examine the doctor. You are challenging the quantum enhancement.
There are 5 fractures. Judgment was passed on 2 in 2021. Because in the peak period of COVID, they are not able to bring the medical. Moreover, my lord, in case they put in the Karnataka 3045. Visual of this common court aspect. In view of this, other social conditions, parents may not be able to get the evidence. Government has to take care to examine the claimant.
Adila. So no medical evidence. So what is the disability? Yaar kottidare? So what has the tribunal done? Not considered anything on disability. ಇಲ್ಲ ಸಿ ಆರ್ ರವಿಶಂಕರ್ ಬರ್ಬೇಕಲ್ಲ. You want a passover? You'll wait. Chetan B. Issue notice. Notice to R1 is dispensed in at risk of appellant. No liability to R1. R2 is the issue notice to R2. Yes, Vijay Kumar D. All right. Madboda. Third learned counsel for the appellant as well as learned counsel for the respondent. This application on IA orders on IA1. This application is filed by the respondent claimant seeking withdrawal of the amount deposited before this court by the insurer. Full stop. IA1 is allowed. Claimant is entitled for withdrawal of the 50% of the amount deposited before this court for the trial tribunal, MSCT tribunal. Registry to release 50% of the amount in deposit to the claimants upon proper verification. Released after next week or 2 weeks? 2 weeks. Issue notice.
Please.
IA number 2 is dismissed as not pressed as the appeal is in time. 1 and no liability on them. 2 is the insurer. 1 and 2 notice dispensed with. Issue notice to respondent 2. IA 1 of 2022 is dismissed as the appeal is in time. Dismissed as not pressed since appeal is in time. Dismissed as not. Notice issue notice. Yeah, I have the 51 huh? 50 aitallama. IA1 is dismissed as not pressed since appeal is in time. Issue notice to respondents. Manjunath.
Number 52. Manjunath MD.
Who is this Manjunath? Yesterday also he was not here, right? Notice to R1 dispensed with. Ravi Samprati for R2. There is no representation on either side. Hence, relist this matter after 2 weeks.
Number 53. Or Shashidharan. Respondent advocate AM Venkat for R3.
I am hearing for the respondent, my lord.
Accident of the year 2016. He was aged about 50 years. The date of accident.
Venkatesh, yeah.
Yes, my lord, I am appearing for Mr. Venkatesh, my lord.
You are ready?
Ready, my lord. Ready. Could be disposed of, my lord.
Yes, sir.
He was 55 years. He was considered age of the 55 years. Taken the income of insurance of money. But in case of the claimant, he was a reconciliation and other business. But we used to have case.
Accident is of the year?
2016. 2016.
Ah.
Claimants are wife and daughter.
All right. So what is the income taken?
6,000 is mentioned by the law.
Ah. What is the avocation? No proof of income. All right. What is the age of that deceased? 55. So 55 under the multiplier. Correct, is yeah. 11 is correct.
11 correct ಇದೆ ಸ್ವಾಮಿ.
$6,000 ತಗೊಂಡಿದ್ದಾರಾ?
ಹೌದು ಸ್ವಾಮಿ 6,000 ತಗೊಂಡಿದ್ದಾರೆ.
What else?
10% future cash flows need to be added to the income.
10%.
10%. ಹೌದು 10% ಕರೆಕ್ಟ್ ಇದೆ.
50 to 60, 10%.
ಹೌದು ಸ್ವಾಮಿ.
10%. So that is added correctly?
Not added.
Not added.
Reduction is 1/3 mass. Well, is rightly divided 1/3.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? Two of them. So 1/3 is correct.
Loss of consortium.
ಎಲ್ಲಿ ಕೊಟ್ಟು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
25,000 towards consortium is awarded.
ಹಾ.
On one allocation, 25,000 is awarded. Other expenses, 25,000 is awarded. As per Pranay's case cost, 3,000 towards loss of person and 50,000 towards loss of.
So that should be 30. Cremation, transportation, fuel, that should be 30. Towards consortium, ಇಬ್ಬರಿದ್ದಾರೆ. 40 plus 40, 80. Towards love and affection. So they've given 50, it should be 80. So instead of 50, it becomes 80. No, together, love and affection will be consortium only. So together with consortium and love and affection, 50 is awarded. You are entitled to 80 because 2 persons are there. Loss of dependency will change. 9 lakh 600. ಮಾಡಿದ್ದೀರಾ ಮಿಸ್ಟರ್ ಏನ್ ನಿಮ್ಮ ಹೆಸರೇನು?
8,000 rupees ತಗೊಂಡ್ರೆ 2016 ಲಕ್ಷ್ಮೀ ನರಸಪ್ಪ.
ಲಕ್ಷ್ಮೀ ನರಸಪ್ಪ
ಸ್ವಾಮಿ ಹೇಳಿ ಸ್ವಾಮಿ.
ಎಸ್
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್
ಎಷ್ಟು ಮಾಡಿದ್ದೀರಾ ಕ್ಯಾಲ್ಕುಲೇಷನ್?
2016
No, have you done the loss of dependency calculation? 9,500.
5,866 into 11, my lord, comes to 7,74,312.
You have done the calculation? Where is the memo? What your file? You should do it in the memo and give it to the court. 9,500 plus 10%. $10,450.
My lord, shall I give the calculation, my lord?
One ನಿಮಿಷ.
Oh, sorry, sir.
What is calculation?
8,500 plus 850. One third, 6,232 into 12 into 11 comes to 8,22,624 plus 70,000 on conventional heads. Plus 40,000 to the minor girl. This all the amount I have to pay. 9,32,624. It comes to including conventional heads, my lord.
10,29,644 rupees.
Sorry, sir.
Total amount. Correct ಇದೆಯಾ?
ಸರಿ ಸರ್. ಇಲ್ಲ ನನ್ನ ಲೆಕ್ಕದಲ್ಲಿ
ಮಾಡಿದ್ರಲ್ಲ. No, the income for calculation will be 6,967 after 10% increment and 1/3 deduction towards personal expense. It will be 6,967 is the income. 6,967 into 12 into 11. 10,29,919,644.
No.
So 919,644 is a loss of dependency.
That
Plus
is wrong, my
80,000.
lord. ಅದು ತಪ್ಪಾಗಿದೆ ಸ್ವಾಮಿ ಅದು.
ಹೇಳಿ.
8,500 plus 10% comes to 9,350.
What is 8,500?
ಇದು ಇನ್ಕಮ್ 2016 ಇನ್ಕಮ್ ತಗೋಬೇಕಾಗಿರೋದು.
9,500. 9,500.
2016 accident.
Oh, correct. Sorry, my lord. Correct. ನಾ 9,500 ಇದೆ. Sorry.
ಅರ್ಸಪ್ಪ ಅವರೇ.
ಸಾರಿ my lord. ನಾನು 8,500 ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ. ಸಾರಿ.
9,500 ಬರ್ಕೊಳ್ಳಿ.
ಸರಿ ಸ್ವಾಮಿ. ಆಯ್ತು.
ನಾವು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀವಿ, ಅಷ್ಟು ನೀವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ.
ಸರಿ ಸ್ವಾಮಿ, ಆಯ್ತು ಮಾಡ್ಕೊಡ್ತೀನಿ.
That's all. No other. Yes, Mr. Council, Shashidhara. ಮಂಜುನಾಥ ಶಶಿಧರ ಅಲ್ಲ? You're Shashidhara? This appeal is preferred by the claimants against the impugned judgment and award passed by the senior civil judge and MACT at Holalakere, hereinafter referred to as tribunal, in MAC 1486 of 2016, dated 21st June 2018. Full stop. This appeal is founded on the premise of inadequacy of compensation awarded to the claimants. Who are the claimants? Who have lost their husband and father, respectively. Full stop. Brief facts of the case. On 21/8/2016, madam, if you don't understand anything, let me know. Don't leave anything blank. 2006, at about 9:30 a.m., 21/8/2016, at about 9:30 a.m., when Hanumantappa was traveling along with Suresh and Kumar on his TVS XL motorcycle, bearing registration number KA17 AS-4638, to attend the opening ceremony of a newly constructed house. The opening and housewarming ceremony of a newly constructed house At that time, when he reached near the land of one Rajanna, the car driven by its driver bearing registration number KA27M819 came in a high speed in a rash and negligent manner so as to endanger human life and safety, and dashed against the two-wheeler ridden by Hanumantappa. To stop. Due to the accident, Hanumantappa and his friends fell down and sustained injuries on their face, right hand, right leg, etc. Immediately after the accident, Hanumantappa was shifted to Megan Hospital, MEGGA, Shumagga. And on clinical examination by the doctor at 11:30 a.m., the doctor declared Hanumantappa to be dead. To stop. It is a case of claimants that deceased Hanumantappa died due to the accident having been suffered which was due to the rash and negligent driving by the driver of the car, namely Sri Suresh, who's the respondent number 1. Full stop. It is further claimed that deceased Hanumantappa was doing agriculture work and also business in kerosene, and was earning an income of 20,000, more than rupees 20,000 per month. Full stop. He was hale and healthy prior to the date of occurrence of accident and was the only sole earning member of the family. The claimants herein are none other than his wife, his widowed wife and minor daughter. Full stop. Due to the unfortunate incident wherein the claimants lost their beloved husband and father respectively, and having incurred certain expenses during this treatment, and having lost the sole breadwinner of the family, preferred a claim petition seeking compensation for the death having been caused by the rash and negligent driving by the respondent number 1, preferred a claim petition seeking compensation. Full stop. Next para. On notice being served to the respondents, respondents number 1 and 2 filed the statement of objection contending, taking the plea that the rider of motorcycle did not have a valid and effective driving license as on date of occurrence of accident. And that further, the respondent took up a plea that respondent number 3 is the insurer and respondent number 2 is the owner of the vehicle. And the vehicle was insured with respondent number 3. Hence, the liability, if any, for payment of compensation would be on respondent number 3, who would have to indemnify respondent number 2. Full stop. Next para. Respondent number 3, insurer, filed his statement of objections, taking the plea that the insured vehicle did not driver of the insured vehicle did not have a valid and effective driving license as on date of the occurrence of accident. It was further pleaded that respondent number 3 was not liable to pay the compensation in view of the owner of the motorcycle and insurer of the motorcycle having not been made party to the claim petition. On these grounds, they sought for dismissal of the claim petition. Next paragraph. On the basis of the pleadings, the tribunal framed relevant issues for consideration. We'll stop. Next para. In order to substantiate the issues and to establish the case, the claimant number 1 examined herself as PW1 and got marked exhibit P1 to P10. We'll stop. The respondent did not lead any evidence, however, got marked exhibit R1 being the insurance copy of the insurance policy consent. Full stop. Next para. After hearing the parties to the proceedings and on consideration of the materials placed before the court, the tribunal partly allowed the claim petition and granted compensation to an extent of 6,03,000 with interest at 6% per annum from the date of petition till date of deposit. The tribunal ordered respondents number 1 to 3 to be jointly and severally liable to pay the compensation. And in view of the insurance policy being in subsistence and valid, the respondent number 3 was directed to deposit the compensation amount. Full stop. Next para. Being aggrieved and being dissatisfied and aggrieved by the judgment and award passed by the tribunal, the unfortunate widow and by respondent number 1. It is further contended that the tribunal has erred in only awarding a meager amount of compensation and has not taken the appropriate income to arrive at computation of loss of income, future earning capacity, or loss of dependency. It is further contended by learned counsel that the deceased, Hanumantappa was doing agricultural activities, along with which he was also doing sale of kerosene business and was earning 20,000 rupees per month, which has been not considered, and thereby the tribunal has erred in not assessing proper income of the deceased to award compensation, thereby causing miscarriage of justice to the claimants herein. It is further contended by learned counsel that the tribunal has erred in not awarding suitable compensation under the head loss of consortium, more so in view of the judgment of the Honorable Apex Court in the case of the National Insurance versus Pranay Sethi, National Insurance Company versus Pranay Sethi, wherein a fixed compensation is prescribed under the head loss of consortium for the parental love, loss of consortium, full stop. Learned Counsel further contends that the tribunal has not taken all these material evidence, both oral and documentary, for consideration and thereby has committed a serious error in awarding meager compensation to the claimants. Full stop. On these grounds, the Learned Counsel for the appellant seeks to allow the appeal and enhance the compensation in favor of the claimants. Full stop. Per contra, Learned Counsel said Lakshmi Narsappa, Lakshmi Narsappa,
Lakshmi Narsappa. Yes, my lord.
Venkatesh, A.M. Venkatesh for respondent number 3, the insurer has vehemently opposed the contentions put forth by the Learned Counsel for the appellant and has contended that the judgment and award passed by the tribunal is in accordance with the material evidence, both oral and documentary, and the same does not call for any interference by this court. He further contends, full stop, he further contends that in view of there being no material proof of income of the deceased Hanumantappa and the claimants having failed to produce necessary materials, either documentary or oral or documentary, the tribunal has rightly assessed the income to be at 6,000 per month, and the same does not warrant interference by this court. He further contends that the tribunal has correctly taken the appropriate multiplier and deducted 1/3 expenses, personal expenses towards the deceased and computed the same for arriving at a just and reasonable compensation, which does not call for interference by this court. Learned Counsel further contends that under the other heads, the tribunal has awarded reasonable compensation, which also does not warrant interference by this court. On the basis of these submissions, he seeks to dismiss the appeal and confirm the order passed by the tribunal. Full stop. Having heard Learned Counsel appearing for the appellant claimants and Learned Counsel appearing for the respondent insurer, I am of the opinion on perusal of the entire material. Trial court record bandidya idralli illa, and the entire material on record, including the exhibits, and on hearing the submissions made by the Learned Counsels, the claimants are entitled to marginal indulgence in enhancement of compensation for the reasons stated herein below. Full stop. It is not in dispute that on 21/8, next para, madam, not in dispute on 21/8/2016 at about 9:30 a.m. when deceased Hanumantappa was traveling on his TVS XL motorcycle along with his 2 friends for attending the housewarming ceremony. The driver of a car bearing number KA27M819 came in a rash and negligent manner and dashed against the deceased Hanumantappa, causing serious injuries, and due to the impact of which the deceased Hanumantappa succumbed to the injuries at the spot and was declared dead by the doctor while he was taken to the nearby hospital. At Megan Hospital, Shimoga. Full stop. In order to prove and establish this fact, the claimant number 1, namely PW1, the widow of deceased Hanumantappa, has produced exhibits P1 to P5 and Exhibit P9, which are the police records. Full stop. Pursuant to the accident having occurred on 21/8/2016, the police have registered a criminal case as against the driver of the vehicle, namely respondent number 1, for the offense punishable under section 304A. Where is that extracted in the judgment? Baradilla? Punishable under section 304A of IPC, read with section 279 and 337. Yellide adu? And full stop. These are the police records which are not challenged either by either of the respondents. Further, no contra evidence has been produced before this court, or any evidence being elicited in the cross-examination of PW1 to disprove these police records produced by the PW1. Full stop. The charge sheet having been filed as against the first respondent, same not having been challenged, can be safely concluded that the driver of the car, the first respondent, was driving the vehicle in a rash and negligent manner, which has caused the accident resulting in the death of deceased Hanumantappa. Hence, negligence is clearly attributed as against the respondent number 1. Full stop. Now coming next paragraph. Now coming to the aspect of the avocation and income of deceased Hanumantappa as on the date of occurrence of accident. Admittedly, in the present case on hand, though the claimants have alleged that deceased Hanumantappa was working as an agriculturist along with doing business in kerosene selling, they have not placed any material before the court to show the income that is derived by deceased Hanumantappa. This fact of non-production of necessary proof of income is undisputed. Full stop. In a situation where the claimants have not produced or unable to produce the necessary proof of income with regard to the earnings, the courts are left with no other option but to do guesswork on the basis of the avocation of the person, namely the deceased herein, to assess the income for computation of compensation. Full stop. Admittedly, the accident has occurred in the year 2016. The notional income chart provided by the High Court Legal Services Authority prescribes 9,500 to be adopted for the accident having occurred in the year 2016. Full stop. In the absence of any proof of income, the courts are left to with no other alternative but to do guesswork. And to arrive at a standard guesswork, the notional income chart has been prescribed by the Legal Services Authority. Full stop. Hence, in the present case on hand, accident having occurred in 2016, the notional income required to be taken is 9,500 per month, as against rupees 6,000 assessed by the tribunal. Hence, full stop. I am in agreement with the contentions put forth by the learned counsel for the appellant claimant that the income of 6,000 assessed by the tribunal is erroneous. The same requires to be enhanced to 9,500 per month. Full stop. Next paragraph. As on the claimant, as on date of the death, was aged about 55 years, which is not in dispute. And in view of the fact that he was aged 50, between the 50 and 60 years, the future earning prospects is to be taken at addition of 10%. Therefore, 9,500 plus 10% would be 10,450.
130. I have calculated, my lord. 6966 into 12 into 11 comes to 9,19,512. Plus 70,000.
One nimisha. You will hear the judgments. Don't interrupt.
1,500 plus 10% would be 10,450.
Full stop. Admittedly, next part. Admittedly, in the present case, the deceased Hanumantappa is survived by his young wife and his minor daughter. Young wife, but a wife and minor daughter. Therefore, there are two dependents on deceased Hanumantappa. Therefore, 1/3 will have to be deducted towards the personal and living expenses of Hanumantappa, deceased Hanumantappa. After deduction of 1/3 on the income arrived at above, which would be 10,450 minus 3,483 would be 6,967 rupees, which would be left for the disbursement of family maintenance. Full stop. Next paragraph. The deceased was aged 55 years, and in view of the same, the appropriate multiplier to be adopted in view of appropriate multiplier adopted would be 11 in view of the judgment of the Honorable Apex Court in the case of Sarla Verma versus Delhi Transport Corporation. Therefore, 6,967 into 12 into 11. 6,967 into 12, 11 would be 9,19,644. This would be the amount towards loss of dependency. Full stop. Next paragraph. As against 5,28,000 awarded by the tribunal. Next paragraph. The tribunal has awarded rupees 25,000 towards love and affection, and towards consortium it is awarded 25,000. Full stop. In view of the judgment of the Honorable Apex Court in the case of National Insurance Company versus Pranay Sethi reported in so and so, the claimant, each of the claimants would be entitled to 40,000 each. Each of the claimants would be entitled to 40,000 towards loss of consortium. Thereby, the claimants are entitled to consortium at rupees 80,000 as against 50,000 awarded by the tribunal. Full stop. Towards cremation, transportation expenses, charges, and other obsequious ceremonies, the tribunal has awarded 25,000. In view of the judgment cited above, in the case of Pranay Sethi, the same requires to be enhanced to 30,000 as against 25,000 awarded by the tribunal. Therefore, on consideration of the above and on enhancement of the income made above, the claimants are entitled to enhancement of compensation as stated in the table below. Full stop. For the reasons above stated, I pass the following order. The appeal is partly allowed. The claimants are entitled for enhancement of compensation from 6,03,000 to yesterday.
10,29,644, my lord.
644, madam. 10,29,644. Up. Next, all other terms and conditions stipulated by the tribunal shall stand intact and the same is not disturbed. Full stop. Next point. The respondent insurer shall pay the enhanced compensation at 6% per annum from the date of the filing of the petition within a period of 4 weeks.
4 weeks, my lord.
Within a period of 4 weeks from the date of receipt of certified copy of the order before the concerned MACT.
Before the MACT.
ಇಲ್ಲೇನಾರ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀವಿ ಸರ್ ಅವಾರ್ಡ್.
All right. Yes, sir. Sorry. Respondent United India ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? Yes, sir. United India Insurance. ಯಾರು? B. Pradeep. Who appears?
No, my lord, I am not representing.
Ilva. Who appears for United India?
United India PB Raj is there.
AM Venkatesh.
Huh?
AM Venkatesh ಹಾಕೊಳ್ಳಿ.
ತಗೊಳ್ತೀರಾ ಮಿಸ್ಟರ್?
ತಗೊಳ್ಳಿ ಸರ್ ಕೊಟ್ರೆ.
Yes, yes. Learned Counsel Shri AM Venkatesh, who is present through VC, accepts notice on behalf of respondent number 2. Low liability against R1? All right. To serve a copy, learned counsel for the appellant to serve a copy on learned counsel for respondent along with the impugned order. Release this matter next week.
15.5, Avishakar Shastri ji.
Appearing for the
Shastri.
appellant, my lord. Case of injury, my lord. Claimant seeking enhancement. We have led evidence of a doctor, my lord, to show that due to the accidental injuries, my lord, permanent disability suffered by the claimant. That aspect of the matter was primarily not touched by the MACT, my lord. If other side seriously disputes about that aspect, records may be necessary, my lord.
Other side dispute model. Ashok Patel, he was here in the morning.
Yes, ma'am.
But he's not here. So when do you want it?
My lord, lordship may call the TCR, my lord, and fix a date, my lord, so that it could be disposed of.
Third learned counsel for the appellant Sri Ravishankar Shastri G. Registry to secure the trial court records. Release this matter after 2 weeks. Prakash.
I appearing for the first respondent in this case.
Yes.
Not in this case, my lord. I'll have it next week, my lord. I will produce some citations, my lordship.
You know what's your defense?
Our engineering student ಅಂತ ಹೇಳ್ಬಿಟ್ಟು last occasion my lordship has noticed that engineering student ಗೆ notional income ಎಷ್ಟು ತಗೋಬೇಕು ಅಂತ ಕ್ವೆಶ್ಚನ್.
ನೋಡಿದ್ರಾ?
MFA 3469 of 19 and 7647 of 2016. I need to produce two citations before this.
ಏನ್ ಹೇಳಿದಾರೆ ಅದರಲ್ಲಿ?
15,000 ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಥರ್ಡ್ ಸೆಮಿಸ್ಟರ್ ಓದ್ತಾ ಇದ್ದಾರೆ. ಇದರಲ್ಲಿ ಥರ್ಡ್ ಸೆಮಿಸ್ಟರ್ ಸ್ಟಡಿಂಗ್ ಥರ್ಡ್ ಸೆಮಿಸ್ಟರ್ my lord. 15,000 notional income has been fixed.
Yes,
and
what
another
is your
one case,
case?
my lord, 8,500 has been considered civil engineer. He was studying the second sem civil engineering.
All right. ಅದು ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತಲ್ಲ ಇದು?
ಬಂದಿದೆ ಸ್ವಾಮಿ. ಅದೇ ಈಗ ಎರಡು ಜಜ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ನಾನು ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಅದಕ್ಕೋಸ್ಕರ.
All right. Let him file that judgment. You have to be quick. Last time only you took time to produce.
Please, my lord. I only took time. Some personal inconvenience, my lord. 2 days I didn't.
Okay. When do you want it?
Any date, my lord. Next week, any date, my lord.
Learned counsel for the. What is your name, madam? Huh? Nitya. V. Kumari Nitya V. You are Wakalat? No. Appearing on behalf of Ms. Shri Prakash MH for the appellant is present physically. Learned counsel B. Pradeep is present through VC. Learned counsel for the respondent submits that he needs some more time to secure the judgment to rely for the purpose of computation of income for a student having suffered in the accident. Release this matter after 2 weeks. This also same matter? Engineering student?
Yes.
No. This is Pradeep is not here in this.
57.
No, Punacha sir is appearing.
Punacha.
Yes, ma'am. Pradeep's case is also
It's
there.
also engineering student.
Next week.
All right. Now that judgment which is passed, which you are relying is 25,000 passed, I think, where I am or one of the party. Whether that was challenged before the Supreme Court. Just find out whether that has been set aside or whether that is modified, or then your stand will become more strong. Mr. Punacha, there is one judgment which is passed. You can take it from Mr. Prakash.
I'll go through it because I have
Wherein I
gone
was
through
a
one
party
judgment where, like Pradeep said, it was 8,500. I'll go into the matter. Next
yes. Release both these matters after 2 weeks.
Sir, number 58, Ravindra M.
There is no liability other than the insurer. R2 and 1 and 2 are owner and driver. So liability is against the insurer. Ravish Benny Elli. He's coming before 1:30. 1:30 ಒಳಗೆ ಬರಕ್ಕೆ ಹೇಳಿ. Keshav Prashant is not present since morning. You dotted ಮಾಡಿ my screen. Mr. Keshav Prashant. Memo for withdrawal of amount.
ಇನ್ಕನ್ವೆನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಸ್ವಾಮಿ. ಇನ್ಕನ್ವೆನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು.
Okay. Sharadamba for R1 to 5. Non-compliance withdrawal. There's no representation on either side of the parties. Hence, release this matter after 2 weeks.
Number 61, Raju Bhatt.
Prasanna.
I have 70 pages soft copy to the concept of
Raju Bhatt. He is not here. Raju Bhatt. There is no representation on behalf of the appellant. However, the cross objector is present before the court. Delist this matter after 2 weeks.
Serial number 62 object. Serial number 63 SV Newton.
Yes, Mr. Hegde.
If the amount is not deposited, arrange for depositing. Not for pending rate.
Kashinath JD,
Kashinath JD, correspondent.
Learned Counsel for the appellant Sri SV Hegde Mulkand is present before the court physically. There is no representation on behalf of respondent. At request of Learned Counsel for the appellant, relist after 2 weeks. Execution hakidara. Stay is subject to deposit. Now you say that you don't know whether they have deposited. What is that? Mukund Devangan's case referred to larger bench. On what point it is referred? Everything is referred? Yes, next. Finally, illa Passover itall. Sorry.
Serial number 35 Passover minus AM Venkatesh. R. Shashidhara for appellant.
I am appearing for the appellant, my lord.
Serial number? You are Mr. Counsel, yeah. What's your good name? You are by 60? Ashwat Narayana. You are waiting for serial number 64. Ian Krishna Swami Barbek. All right, we'll take up this matter. I'll finish off the Passover and come back. In the meanwhile, if you can call him, very well and good. No problem, no problem. Yes, he is effective. Yes. AM Venkatesh, serial number 35.
R. Shashidhara for appellant.
I am appearing for the appellant, my lord. Insurer appeals for me only as quantum and interest, my lord. It is challenged before this court.
R. Shashidhara avagle bandidralla avare. Padi.
ಅವರೇ ಸರ್.
ಬರ್ಲಿ. You can just send him a message.
Sorry, wait, Martin.
What is your case, Lakshmi Nasappa?
Date of accident is 6/12/2014.
The insurer's appeal, huh?
House Swami.
United yes.
Industries.
Liability is on you.
Liability is on me, my lord.
Yes.
Injured claimant is Manjuna, aged about 26 years. He was said to be a agriculturist and part-time lecturer.
Agriculturist and part-time lecturer.
Yes, my lord.
All right.
Earning rupees
2014
per month. 70,000 ರೂಪಾಯಿ ಸಂಪಾದನೆ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್. both.
Earning 70,000.
Agriculture plus the lecturer ಇಂದ ಎರಡು ಸೇರಿ.
50,000 plus 20,000.
MS Ramaya Hospital ಅಲ್ಲಿ 5-day inpatient, my lord. Page number 9, my lord. Go to page number 9. Injury, my lord, could get at page number 7 of the learned.
Now he says he's a guest lecturer in Degree College, Kunigal.
ಹೌದು. Exhibit P7, P8 ಎರಡು ಕಾಲೇಜಲ್ಲಿ ಲೆಕ್ಚರ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. No author is examined, my lord. ಒಂದರಲ್ಲಿ 6,000 ರೂಪಾಯಿ, ಇನ್ನೊಂದರಲ್ಲಿ Exhibit P8 and P7.
Two service certificates, huh?
Also,
All right. What is the service certificate? What does it say?
ಅಂದ್ರೆ ನಮ್ಮ
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ.
Payment ನಿಮ್ಮ ಹತ್ರನೇ ಇರಬೇಕು.
Except that nothing is.
What is the service certificate? Now, what does the service certificate read?
I will read my letter to the court. P7 ಬಂದು ಸರ್ಕಾರಿ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜು ಕುಣಿಗಲ್ಲು. ಶ್ರೀ ಮಂಜು MP ವಾಣಿಜ್ಯ ಶಾಸ್ತ್ರ ಅತಿಥಿ ಉಪನ್ಯಾಸಕರು ಸರ್ಕಾರಿ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜು ಕುಣಿಗಲ್. ಇಲ್ಲಿ 2012ರಿಂದ 13ನೇ ಸಾಲಿನಿಂದ ಈ ಕಾಲೇಜಿನಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾರೆ ಹಾಗೂ ಸದರಿಯವರು ಮಾಹಿಯಾನ 8,000 ಗೌರವಧನವನ್ನು ಪಡೆಯುತ್ತಿದ್ದಾರೆ. ಅದು P7 ಮೈಲಾಡ್. ಆಮೇಲೆ P8 ಬರ್ತೀವಿ ಸ್ವಾಮಿ. ಇವಾಗ ಅದು BGS ಸೈನ್ಸ್ ಇಂಡಿಪೆಂಡೆಂಟ್ PU ಕಾಲೇಜು ಕುಣಿಗಲ್ ಅಲ್ಲಿ ಸೇವಾ ದೃಢೀಕರಣ ಪತ್ರ. ಶ್ರೀ ಮಂಜು MP ಲೆಕ್ಕಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರು. ಇವರು ನಮ್ಮ ಕಾಲೇಜಿನಲ್ಲಿ ದಿನಾಂಕ 17/6/13ರಿಂದ 31/3/15 ತನಕ ಅರೆಕಾಲಿಕ ಉಪನ್ಯಾಸಕರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿಯವರು ಮಾಹಿಯಾನ 6,000 ರೂಗಳ ವೇತನ ಪಡೆಯುತ್ತಿದ್ದರು ಎಂದು ಈ ಮೂಲಕ ದೃಢೀಕರಿಸಿದೆ. These are the two exhibits which I have placed before the learned judge, my lord.
All right, but no evidence led.
No evidence led. No evidence led by the claimant.
All right.
The error on the part of the learned judge taking income at 12,000 rupees. Kindly come to page number 9.
Page number 9.
Yes, my lord.
Yes.
12,000 ರೂಪಾಯಿ ಇನ್ಕಮ್ ತಗೋತಾರೆ learned judge.
Which para?
Para number
18.
18 my lord. Page 9 ಅಲ್ಲಿ 18 ಅಲ್ಲಿ. Shall I read it, my lord?
Yes, yes.
So far as the income age of the petition, there is no direct proof. Learned judge ಒಪ್ಕೊಳ್ತಾರೆ proof ಏನು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. But still the income the claimant at 12,000 rupees where there is no basis, my lord. ಇದು ಅವರು ಡಾಕ್ಯುಮೆಂಟ್ ಆತನ ಎಕ್ಸಾಮಿನ್ ಪ್ರೂವ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ನೋಷನಲ್ ಆಗಿ ಕೋರ್ಟ್ ಲೋಕ ಅದಾಲತ್ ಎಷ್ಟು ತಗೊಳ್ತಾ ಇದೆಯೋ ಅಷ್ಟು ತಗೋಬೇಕು ಅಂತ ಹೇಳಿಬಿಟ್ಟು ನನ್ನ ಪ್ರಾರ್ಥನೆ ಈ ಕೋರ್ಟ್ಗೆ ಸ್ವಾಮಿ.
ಎಸ್, ನಿಮ್ಮ ಪ್ರಾರ್ಥನೆ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ.
ಸರಿ ಸ್ವಾಮಿ. ಆಮೇಲೆ PW2 ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರೆ. ರೈಟ್ ಲೋಯರ್ ಲಿಂಬ್ಗೆ 26% ಹೇಳ್ತಾರೆ ಡಿಸಬಿಲಿಟಿ. ಪ್ಯಾರಾ ಪೇಜ್ ಕಮ್ ಟು ಪೇಜ್ 7 my lord. Para 15. 15 my lord. Page 7 para 15.
Yes, yes.
The doctor has opined that injuries are grievous in nature. Further, the petition
just read before that.
the evidence of Dr.
Before that.
Deep the issue that. Number 3. Deep lacerated wound.
1 2 3 ಓದಿ.
1 2 3. ಅದೇ deep lacerated wound over right hand, profuse bleeding 15 centimeter between index and middle finger. 2 lacerated wound over right eyeball, right 3 inches. Abrasion over right knee into 2 inches. These are the injuries he has suffered. The para 15, Dr. Sandeep Reddy from MS Ramaya College was examined as PW2, who assessed disability to the extent of 26% to the right lower limb. Taking it to 1/3, a learned judge come to the conclusion it is about 8.6%, but finally learned judge has took it as 9%. 9%. It has no consequence, my lord. And that is at para 17 of page 8. Besides the petition is entitled ಅದು 9% ತಗೊಂಡಿರೋದಕ್ಕೆ para 17 ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ learned judge.
What does the doctor say? How much percent disability?
ಅದು that is at 15 para. Shall I read?
26%.
right lower
So
limb.
as per the PW2, it is 26% permanent disability to the right
lower
upper
limb,
limb,
my lord.
and 1/3 of it,
Right
as per
upper
his
limb.
own opinion, is 8.6% permanent physical disability.
Exactly, my lord.
Right upper limb. All right. X-ray besides.
ಅದು ದಾರ 17 next page ಅಲ್ಲಿ
So
learned
it's a
judge 9%
so
ತಗೊಂಡಿದ್ದಾರೆ.
26% divided by 3.9 ಮಾಡಿದ್ದಾರೆ.
ನನಗೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ ಅದ್ರ ಮೇಲೆ.
So you have no quarrel on that.
ಇಲ್ಲ 8.9%, 8.6 ಅನ್ನು ತಗೊಂಡಿದ್ದಾರಲ್ಲ, doesn't matter much, my lord.
All right. Yes.
ಅದಕ್ಕೇನು ತೊಂದರೆ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ 9ನೇ ಪೇಜ್ ಅಲ್ಲಿ ಲರ್ನೆಡ್ ವಿತೌಟ್ ನೋ ಬೇಸಿಸ್ 12,000 ರೂಪಾಯಿ ಇನ್ಕಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಅದು ಆಲ್ರೆಡಿ ಯು ಹ್ಯಾವ್ ಆರ್ಗ್ಯೂಡ್. ನೆಕ್ಸ್ಟ್
ದಟ್ ಅದಾಗೋದ್ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ 9% ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Yes.
And these ಇಷ್ಟೇ ಸ್ವಾಮಿ. ಯಾಕೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ದೇ ಹ್ಯಾವ್ ಕಂಪ್ಲೇಂಟ್ ಬೈ ಪ್ರಸನ್ನ ಕುಮಾರ ಕಂಪ್ಲೇಂಟ್. ಅದು FIR 5 days ಲೇಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಆಫ್ಟರ್ ದ ಆಕ್ಸಿಡೆಂಟ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್ FIR. Even ಪ್ರಸನ್ನ ಕುಮಾರ್ examined. No independent evidence was let in by the claimant. Of course, I did that also. They not let any further evidence, my lord, before the learned judge, except marking the policy, my lord. And interest is at 10%, which is on higher side, which has to be notionally considered. And further, my lord, one more issue, my lord. He appears, it's said to be a guest lecturer. His loss of future is 2,30,320. There is no evidence. ಅವ್ರಿಗೆ ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಬರುವುದಕ್ಕೆ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಲೆಕ್ಚರರ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದು ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ. ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದು ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ. ಸೊ 9% ಡಿಸಬಿಲಿಟಿ ಅಲ್ಲಿ ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಇಲ್ಲ ಅಂತ ನನ್ನ ವಾದ, ಮೈ ಲಾರ್ಡ್, ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಲೆಕ್ಚರರ್ ಆಗಿ ಒಂದ್ ವೇಳೆ ಪಾಠ ಮಾಡೋದಿದ್ರೆ ಮಾಡಬಹುದಾಗಿತ್ತು ಇವರು. ಅದು ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಇವ್ರ ಎವಿಡೆನ್ಸ್ ಏನು ಇಲ್ಲ. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು PW1 and PW2 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಮೈ ಲಾರ್ಡ್, ಬೈ ಮೀ.
Have you cross examined the witness PW1 by stating or questioning whether one ನಿಮಿಷ ಕೇಳಿ. Have you cross examined witness PW1 by asking or suggesting that you have continued with your avocation of guest lecture and you are continuing with agriculture work?
ಆ ಕ್ವಶ್ಚನ್ ಕೇಳಲಿಲ್ಲ ಸ್ವಾಮಿ, ಆ ಕ್ವಶ್ಚನ್ ಕೇಳಲಿಲ್ಲ.
Whether he has produced any document?
Exhibit P1 cross examination I have taken. PW2 is also cross examined by the appellant, my lord. ಅದು ಮೈ ಲಾರ್ಡ್ಸ್ ಪೇಜ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ಇದೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ. ಅದು
How many days you are inpatient?
5 days. 5 days.
All right.
Cross examination.
So what is the amount awarded?
3,99,320 with 9% interest, my lord.
5 days. So inpatient 5 days, sir.
House
only 2,000 awarded. Yes. All right. So what should be considered as income according to you?
Honorable Adalat ಏನ್ ಫಿಕ್ಸ್ ಮಾಡಿದೆಯೋ ಅದು ಇನ್ಕಮ್ ಪ್ರೂವ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ, my lord, I wanted to relay one of the judgments of this court, my lord. When a document, my lord, when a document, any document for that matter, produced and insured, if this disproves, it is for the claimants to prove the document by ILR 2007. Karnataka 4567.
What does it say?
Para 14, my lord.
Is it a division bench or it is single judge?
ಇಲ್ಲ, single bench, Swami.
Single.
Though the issue
You
in
have
this,
not preferred any enhancement. Really, sir.
Para 14, my lord.
Please read because you have not given me a copy.
Yeah, please, my lord. No, sorry, my lord. I was only online. Section 102 of the Evidence Act 1872 states that the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Section 105 provides for burden of proving the existence of circumstances by the person accused within any general exceptions in the Indian Penal Code or with any special exception or proviso contained in any other part of the same code or in any law defining the offense, and the court shall presume absence of such circumstances. Section 106, that when any fact is especially within the knowledge of any person, the burden of proving that fact lies upon him. So it is for him to prove the document which he is relying upon, exhibit P7, P8, my lord. And at para 8 of the same judgment, my lord, this is, though that's what I have placed before the Honorable Court, that it is pertaining to DL issue, but the same document has to prove by the place per contra. A. Ravi Shankar, Learned Counsel for the first responder insurance company, contends that the fact of entrustment of a vehicle in question by the owner is duly licensed driver on the relevant date, especially within the knowledge of the owner, and said Shankar Pujari, not having been established by adducing evidence of the witnesses, cannot claim to have discharged the initial burden of valid entrustment of filing the statement of objections. Learned Counsel further contends that in view of section 101, 102 to 106 of Evidence Act 1872, ensured that the driver have not adduced any over entitlement of the bus adverse inference need to be drawn against the insured. A document on prove ಮಾಡಲಿಲ್ಲ ಅಂತಂದ್ರೆ it could be inferred ಅಂತ, my lord.
This was on the basis of the insurance company.
Also,
which had taken the plea.
Yashodhara B. Shetty, United India Company. But issue, but para 14 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ document produce them to prove ಅಂತ. That is what I have brought it in notice of this court, my lord.
Which para you are reading?
14, my lord. 14 ಓದಿದೆ ಈಗ. 14 ಓದಿದೆ ನಾನು ತಮ್ಮ ಹತ್ರ. ಅದು ಪೇಜ ಪ್ಯಾರಾ 14, 15 ಎರಡು ಓದಿದೆ ಸ್ವಾಮಿ ತಮ್ಗೆ. 13, 14, 15 ರಿಲೆವೆಂಟ್ ಪ್ಯಾರಾಸ್, ಮೈ ಲಾರ್ಡ್.
Yes.
Please, that's all, my lord. And my appeal may kindly be allowed and notionally fix the income of the claimant, since there is no loss of income to the claimant. As if,
yes, sir.
That's all the submission.
Okay. You are able to hear learned counsel?
ಇಲ್ಲ, ಕೇಳಿಸ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ಕೇಳಿಸ್ತಾ ಇದೆ.
Agriculturist. Also, they are working as a guest lecturer. Claims his income through agriculturist.
His argument is that though you have stated exhibit P6 and 7 and 8, 8,000 plus 6,000, you have not examined the author. You have not produced any material to show that you are drawing income in the agriculture. Neither here. That is his argument. So when there being no evidence, have to go back to the chart is what his argument is. And no income award ಮಾಡಬೇಕು ಅಂತ is what he's.
Submission with the last week is two service certificates are produced. Issued by
Whoever it may have been.
BGS College.
You have not examined the author.
This is the BGS College, Bengal. And my lord, the first page card, my lord, these are two reputed colleges where he was working. That's the last to the these two colleges plus reputed college. So further two not
Necessary. If it is reputed. Everybody, I do not know, sir. I do not know, and my the learned tribunal judge before the tribunal also may not know. How can we go on the presumption that they are reputed? Even if it is so, what stopped you from examining the author of the document who was given the document?
Not able to examine the author of those documents. But my lord, however,
Then what stopped you from producing any proof of that income accounted to your bank if you had received?
Including my lord, the agriculture income and also the this income as 12,000 is just.
Correct. That just and reasonable is now questioned. At least you should have produced some material.
Not produced.
Bank passbook era kodbekagittala ನೀವು. Why? Then how to sustain this order?
Passport is not produced. But the submission marks what is 12,000. Accident of the 2014. Apart from this, the list of those two documents, also agriculture income is just.
Yes, Mr. Narsappa, Lakshmi Narsappa.
ಒಮ್ಮೆ ಅಗ್ರಿಕಲ್ಚರ್ ಇನ್ಕಮ್ ಅಂತ ಅವರು ನಮ್ಮ ಬ್ರದರ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಏನನ್ನ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ ಕೋರ್ಟ್ ಮುಂದೆ
ಆಯ್ತು. ಇವಾಗ have you disputed the fact that he is a guest lecturer and qualified? What is your qualification?
Nothing is placed before the judge, before the.
What is your qualification? At least you must have said so in your evidence. Teaching which class?
The degree college lecturer.
Degree college. What is your qualification, sir? Degree college. So to teach degree college, you must be definitely a postgraduate. ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಅದು? ನಾವು ಅಸ್ಯೂಮ್ ಮಾಡ್ಕೋಬೇಕೇನೋ? Please, you should ascertain, sir, before you argue the matter.
Kindly see the exhibits P1 to 14, my lord. Nothing is placed before the learned judge.
No, you are not disputed. You are not disputed that he is a lecturer.
ಅಲ್ಲ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೋಡಿ ಸೊಮ್ಮೆ. ನಾನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದಾಗ ಏನ್ ಹೇಳಿದಾರ ಲೆಕ್ಚರರ್ ಅವರು? ದಟ್ ವಿಲ್ ಬಿ ಕ್ಲಿಯರ್ ದಿ. ಓದ್ತೀನಿ ಸೊಮ್ಮೆ.
Read sir.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್. ಮುಂದುವರೆದ ಪಾಟಿ ಸವಾಲು ಬಿಜಿಕೆ ವಕೀಲರಿಂದ. NP 10 ಸಂಪೂರ್ಣ ಔಷಧಿ ಚೀಟಿಗಳು ಬಿಲ್ಲುಗಳು ಕೇವಲ ಪರಿಹಾರ ಪಡೆಯಲು ಸೃಷ್ಟಿ ದಾಖಲೆಯನ್ನು ಸುಳ್ಳು. MS ರಾಮಯ್ಯ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಯಾವುದೇ ಬಿಲ್ಲುಗಳು ನನ್ನ ಹೆಸರು ಇಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಶ್ರೀದೇವಿ ಆಸ್ಪತ್ರೆ 2400 ಔಷಧಿ ಬಿಲ್ಲುಗಳನ್ನು ಯಾವುದೇ ಚಿಕಿತ್ಸೆ ಪಡೆದೇ ಹಾಜರು ಮಾಡಿದ್ದೇನೆ ಎನ್ನುವುದು ಸುಳ್ಳು. ಹೆಲ್ಪ್ ನೆಸ್ಟ್ ನವರು ಕೊಟ್ಟಿರುವ 2 ಲಕ್ಷ ಬಿಲ್ಲುಗಳು 2300 ಮತ್ತು 6200 ಇವುಗಳು ಆಧಾರ ರಹಿತ ಮತ್ತು ನಕಲಿ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸರ್ಕಾರಿ ಕಾಲೇಜಿನಲ್ಲಿ 2011-12ರಿಂದ 2014-15ರವರೆಗೆ ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ ಆಗಿ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. ನಿಶಾನೆ P7ರಲ್ಲಿ ಕೇವಲ 2012-13 ಸಾಲಿನಲ್ಲಿ ಮಾತ್ರ ಆ ಕಾಲ ಕೆಲಸ ಮಾಡಿದ ಬಗ್ಗೆ ನಮೂದಾಗಿದೆ. ಹಾಗಾಗಿ ನಾನು 2015ರವರೆಗೆ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸದರಿ ಕಾಲೇಜಿನಲ್ಲಿ ಸಂಬಳವನ್ನು ಚೆಕ್ ಮುಖಾಂತರ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಚೆಕ್ ಮುಖಾಂತರ ಕೊಟ್ಟಿದ್ರೆ ಸದರಿ ಸಂಸ್ಥೆಯಿಂದ ಸಂಬಳ ಪಡೆದ ಬಗ್ಗೆ ಬ್ಯಾಂಕ್ ದಾಖಲಾತಿ ಹಾಜರು ಮಾಡಿಲ್ಲ. ನಿಶಾನೆ P8 ಎಂದರೆ BGS ಕಾಲೇಜಿನ ದಾಖಲೆ. ಕೇವಲ ಪರಿಹಾರ ಪಡೆಯಲು ಸೃಷ್ಟಿ ಮಾಡಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸದರಿ ಕಾಲೇಜಿನಲ್ಲಿ ನಾನು
do you have any material now for
ಕಾಲೇಜಿನವರು ನಗದಾಗಿ ಸಂಬಳ ಪಾವತಿಸಿದ್ದರು.
Lakshman
ಹಾಗಾಗಿ
Asappa ಅವರೇ,
ಸ್ವಾಮಿ
you got disconnected somewhere when you started exhibit P8.
ಹೌದು ಅದು ಪವರ್ ಹೋಗ್ಬಿಡ್ತಿಲ್ಲಿ ಅದಕ್ಕೋಸ್ಕರ.
So now you read from P8, exhibit P8.
P8 ಇಂದ P8 ಅಂದ್ರೆ BGS ಕಾಲೇಜಿನ ದಾಖಲೆ ಕೇವಲ ಪರಿಹಾರ ಪಡೆಯಲು ಸೃಷ್ಟಿ ಮಾಡಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸದರಿ ಕಾಲೇಜಿನಲ್ಲಿ ನಾನು ಉಪನ್ಯಾಸಕನಾಗಿ ಕೆಲಸ ಮಾಡಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. BGS ಕಾಲೇಜಿನವರು ನಗದಾಗಿ ಸಂಬಳ ಪಾವತಿಸುತ್ತಿದ್ದರು, ಹಾಗಾಗಿ ಅದರ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇರುವುದಿಲ್ಲ. BGS ಕಾಲೇಜಿನಲ್ಲಿ ನನಗೆ ಯಾವತ್ತು ನಗದಿನ ಮೂಲಕ ಉಪನ್ಯಾಸ ಸಂಬಳ ಪಾವತಿಸಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ವಾರದ ಮೊದಲು 3 ದಿನದಲ್ಲಿ ಒಟ್ಟು 8 ತಾಸು BGS ಕಾಲೇಜಿನಲ್ಲಿ ಮತ್ತು ನಂತರ 3 ದಿನ ಒಟ್ಟು 8 ತಾಸು ಡಿಗ್ರಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ. 2 ಕಾಲೇಜಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದಾಗ ಹಾಜರಾತಿ ಪುಸ್ತಕ ಸಹಿ ಮಾಡಿದ್ದೇನೆ, ಆದರೆ ದಾಖಲೆಯನ್ನು ಪ್ರಕರಣದಲ್ಲಿ ಹಾಜರು ಮಾಡಿಲ್ಲ.
Yes.
That's all. That is pertaining to that issue, my lord. Which.
So where is your question that you are not at all a qualified guest lecturer?
ಇಲ್ಲ ಆ ಕ್ವಶನ್ ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ, ಅದೊಂದು ಕೇಳಿಲ್ಲ. ಇವ್ರ ಸಂಬಳದ ಬಗ್ಗೆ ಕಾಲೇಜಿನ ಬಗ್ಗೆ ಕೇಳಿದ್ದೇನೆ ಹೊರತು.
All right. Yes, sir. Anything else? That's all.
That's all, my lord. Doctor.
Nothing.
PW2 ಡಾಕ್ಟರ್ದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಒಂದು 2 ಲೈನ್ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬೇಕಾಗಿತ್ತು, ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ.
On what point?
ಡಿಸಬಿಲಿಟಿನೂ ಅಷ್ಟು ಬರುವುದಿಲ್ಲ ಅಂತ ಸ್ವಾಮಿ.
Disability ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? Where is the amount awarded towards disability?
2,30,320 ಕೊಟ್ಟಿದ್ರು ಸರ್ ಲರ್ನೆಡ್ ಜಡ್ಜ್. 12,000 ತಗೊಂಡು
ಡಿಸಬಿಲಿಟಿ ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ? ಎಲ್ಲಿ?
Considered 9% disability.
Disability is on the basis of what is the material? That's 1/3, that's 26%. That's correct. So 26% disability assessed by the doctor is divided by 3. 1/3.
ಲರ್ನೆಡ್ ಜಡ್ಜ್ 9 ತಗೊಂಡಿದ್ದಾರೆ. That's not
rounded off to 9%.
ಹೌದು ಸ್ವಾಮಿ, ಅದನ್ನ ತೊಂದರೆನೂ
So note.
ನಾನು ಮಾಡ್ತಾ ಇಲ್ಲ.
ಆಯ್ತು sir, your only argument is with regard to the income on the basis of agriculture and that guest lecture. That is all.
ಇಂಟ್ರೆಸ್ಟ್ 9% ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಹೈಯರ್ ಆಯ್ತು ಅಂತ ಸ್ವಾಮಿ.
ಇಂಟ್ರೆಸ್ಟ್ ಕರೆಕ್ಟ್ ಇದೆ ಬಿಡಿ.
ಅಲ್ಲ 9% ಮೈ ಲಾರ್ಡ್.
9%.
9% ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ.
9% ಕೊಡ್ತಾರೆ, ಅದರಲ್ಲೇನು
ಇಲ್ಲ ಸ್ವಾಮಿ. ನಾರ್ಮಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹಾನರಬಲ್ ಬೆಂಚ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಗ್ರಾಂಟೆಡ್ ಓನ್ಲಿ 6%, my lord. That is also question.
All right, sir.
Please,
where does it say that 9% should not be granted?
ಇಲ್ಲ, ಆ ತರ ಯಾವುದು ಇಲ್ಲ. ಸಾಮಾನ್ಯವಾಗಿ ಈ ಕೋರ್ಟ್ 6% ಕೊಡ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
All right.
Please, my lord.
There is nothing much, sir. Tribunal is right in awarding compensation. Although the amount, the notional income chart is only for a reference basis if there is no proof of income for a coolie. Here is a postgraduate who is teaching in degree college. So combining that with the agricultural income, though he has not produced, so 12,000 is reasonable. Barkoli. This appeal is directed against the judgment and award passed by the senior civil judge and MACT 115 at Kunigal in MVC 438 of 2015 dated 14th March 2019 by the insurance company. This appeal is founded on the ground of excessive compensation awarded by the tribunal. Full stop. brief facts. On 16/12/2014, at about 11:30 p.m., while the claimant was traveling as a pillion rider on the bike bearing registration number KA06ER3818, which was ridden by one B. Prasanna Kumar, following the necessary traffic rules and regulations. At that time, a two-wheeler Yamaha model bike bearing KA06R9449 came from the opposite direction, ridden by the rider in a high speed in a rash and negligent manner near Bilakalpalya, so as to endanger human life and safety, and dashed against the claimant's bike. Full stop. Due to the impact of accident, the claimant and the rider fell down and sustained injuries to their person and body. Both of them were shifted to the Gubbi Government Hospital for initial treatment, and thereafter they were shifted to Sridevi Hospital and subsequently to MS Ramaya Hospital for better treatment. Yes. Due to the injuries sustained in the accident, the claimant incurred financial expenditure for treatment and was admitted in the hospital for a period of 5 days as inpatient, and due to which he lost the earning capacity because of the disability suffered by him, and also the income during the period he was admitted as inpatient in the hospital. For all these reasons, the claimant preferred a claim petition seeking compensation for the injuries sustained by him and the loss of income. Full stop. Next para. On notice being served to the respondents who appeared before the court, the respondent number 2 filed a statement of objections, who's the insurer of the first respondent, and pleaded that the accident occurred due to the negligence of the rider of the bike, namely the claimant, the rider of the bike, and not due to the rider of the offending vehicle. It was also pleaded by the insurer that there was a delay in registration of the delay of 5 days in registration of the FIR, which are also is suspicious in nature with regard to the involvement of the offending vehicle in question herein. It is further pleaded that the injury sustained by the claimants was due to their own fault of not wearing a protective headgear, namely helmet, and that there was contributory negligence on the part of the claimant and the rider of the vehicle as against the offending vehicle. Hence, he sought for dismissal of the claim petition. It was it was also pleaded that the rider of the offending vehicle did not possess a valid and effective driving license and violated the terms and conditions of the insurance policy. However, the policy came to be admitted by the insurer. The same was also marked as an exhibit R1. Full stop. This being on the basis of these pleadings, the tribunal framed relevant issues for consideration. In order to substantiate the issues and establish the case, the claimant got examined himself as PW1 and got marked exhibits P1 to P14. Whereas on the other hand, the respondent did not lead any evidence, however, got marked the insurance policy with consent as exhibit R1. Full stop. Next paragraph. It is the vehement contention of learned counsel appearing for the appellant insurer that the tribunal has grossly erred in not considering the material evidence, both oral and documentary, and has mechanically passed an order assessing the income of the claimant to be at rupees 12,000 per month without any material basis and proof. Hence, the same requires to be reduced, and hence same requires to be reduced. It is further contended by learned counsel that there is no proof of income produced by the claimant despite which the tribunal has assessed the monthly income of the claimant to be at 12,000 rupees on the basis of exhibit P7 and P8, which is erroneous in law for the simple reason that the claimants have not examined the author of the said document, exhibit P7 and P8. He further contends that the claimant has not produced any material evidence to show that he was also doing agricultural activities, and no proof of income to that effect is also produced. It is further contended by learned counsel that when the claimant relies on a certificate of proof of income, the onus is on the claimant as contemplated under section 106 of the Evidence Act. Under 2 of the Evidence Act, Indian Evidence Act 1872, and 106 of the Act, which is upon the claimant to establish and prove that fact which is within his knowledge. In the present case on hand, though the claimant has produced exhibit P7 and P8, the same is not established as contemplated under law by adducing the evidence of the author of the said document. Full stop. It is also contended that nothing prevented the claimant from producing the bank passbook or entries made in the bank account with regard to deposit of the said amount having been paid by the said colleges for disbursement of income to the claimant. Full stop. Next, learned counsel further contends that the evidence adduced by the doctor in PW2 with regard to the disability is on the higher side, and hence the same is not appropriately considered with regard incommensurate to the injuries sustained by the claimant. Therefore, the same also requires to be reconsidered by this court with regard to the disability arrived at by the tribunal. Learned counsel further contends that the tribunal has awarded interest at the rate of 9%, which is also exorbitant, and the same requires to be toned down to 6%. It is a contractual policy, and as it is not a contractual policy and only a statutory policy. He further contends that the maximum interest that could be awarded is only 6%. Hence, the interest awarded requires to be reduced from 9% to 6%. Lakshmi Narsappa, where is the interest considered under the MV Act, under which section? One, not considered. So in the entire MV Act, it's not considered at all.
Page number.
No mention of interest. So you'll have to go back to the.
No, page 11, my lord.
Ilri, Nimdu interest act, you are saying that interest should be toned down.
How so,
6%. Where does the Motor Vehicles Act say that it should be 6%? Where does the Act specify?
Division bench ruling on the this court, my lord.
Huh?
In MFA.
It is also the contention of learned counsel for the appellant claimant, insurer, that the interest awarded by the tribunal is on the higher side. The same requires to be toned down to 6% as contemplated under section 149(1) of the MV Act. Elli there ade 149(1) alli. Full stop. Per contra, next. Learned counsel appearing for the claimant contends that the tribunal has awarded compensation on the basis of material evidence, both oral and documentary. Therefore, the tribunal has not committed any error in assessing the income to be at ₹12,000 per month, as the tribunal has rightly taken into consideration Exhibit P7 and P8, wherein the claimant is a guest lecturer for a degree college and was earning ₹8,000 from one college and ₹6,000 from another college, wherein by giving guest lecture for a period of 3 days in each colleges. The said document are marked as Exhibit P7 and P8. Apart from doing agriculture work. Full stop. The moot point for argument or consideration before this court is whether it is also contended by learned counsel for the claimant that he has examined PW2, the doctor, who has assessed the disability to an extent of permanent physical disability, and on the basis of same, the tribunal has assessed the disability to the whole body at 9%. Would not interference for the simple reason that the tribunal has relied on the expert opinion expressed by the doctor BW2. He further contends that under the other heads, the tribunal has assessed just and reasonable compensation for awarding compensation, even for the loss of income during laid-up period and for having been inpatient for a period of 5 days. He further contends that the interest awarded by the tribunal is just and reasonable, and there is no curtailment of the Motor Vehicles Act with regard to interest being capped or fixed at maximum 6%, as passed by the Learned Counsel for the insurer. Idian
As per may
anywhere
make
there
one
in
submission.
Interest Act.
So
30+.
Nano, I wanted to have one submission, my lord.
Yes.
Honorable Division Bench of this court in MFA 5896 of 18 decided on 24/8/20 between Joyita Bose and Venkatesh. Honorable court upheld the contention of the insurer in that case and reduced it from 8% to 6%, my lord. Relevant
So whether that is only on the facts and circumstances of that case, or it applies to everyone.
Para 51, I will read, my lord. If my
read it.
It is seriously contended by the learned counsel for the respondents, insurance company, that the award of interest at 8% is on a higher side. We accept the said contention. Section 34 of the CPC read as under 34 interest, where and in no so far a decree of payment of money, the court may in the decree order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged from the date of suit to the date of degree, in addition to any interest adjudged on such principal sum for a period prior to the institution of the suit, with further interest of such rate not exceeding 6% per annum. In the court deems.
Yes. Yes, sir. Noted. Yes, Enama Bardre.
Further contends that the interest awarded by the tribunal is just and reasonable, but there is no curtailment under the Motor Vehicles Act, being interest capped or fixed at 6% as canvassed by the Learned Counsel for the insurer.
Full stop. On the basis of these submissions, Learned Counsel for the claimant seeks for dismissal of this appeal and to affirm the judgment and award passed by the tribunal. Full stop. Having heard the submissions and contentions of the Learned Counsel and the Learned Counsel respondent claimant, the point that would arise for consideration before this court is whether the tribunal has awarded excessive compensation to the claimants considering the facts and circumstances of the case to stop, and whether the tribunal has excessive interest at the rate of 9% instead of awarding 6%. Full stop. And whether the order of the tribunal calls for interference. Full stop. It is not in dispute that the accident occurred on 16/12/2018 at about 11:30 p.m. while the claimant was traveling as a pillion rider with his friend. The Yamaha vehicle motorbike bearing KA06R949 came from the opposite direction in a high speed in a rash and negligent manner and dashed against the bike ridden by the friend of the claimant, leading to the injuries suffered by the claimant. Full stop. To evidence this fact, the claimant has got exhibits P1 to P6 Full stop. These are the police records which are produced pursuant to the investigation and inquiry conducted by the investigating agency. These documents are admittedly not challenged or not disputed by the appellant insurer or the rider of the motorbike. Full stop. When this being the facts of the case, and there being no challenge to these police records and the criminal case having been registered as against the rider of the motorbike, and no contra evidence having been produced by the respondent insurer, either before the tribunal or before this court, it can be safely concluded that there is rashness and negligent riding on behalf of the rider of the motorbike Yamaha motorbike, which led to the accident in which the claimant sustained injuries to himself and incurred financial expenditures. Full stop. Now, the second point for consideration would be what should be the income awarded to the, what should be the income assessed for the claimant for computation of compensation. Admittedly, in the present case on hand, the claimant has not produced any specific material proof of income to show that he was earning 12,000 rupees per month as income, both from agricultural activities and also as a guest lecturer. No doubt, the claimant has produced Exhibit P 7 and 8, which are two certificates, service certificates issued by two colleges, which says that the claimant was working as a guest lecturer and earning rupees 8,000 and 6,000 rupees per month respectively in two colleges by attending 3 days in each of the colleges in a week. Full stop. On the basis of this Exhibit P7 and P8, the tribunal has assessed the income, monthly income of the claimant to be at rupees 12,000 per month for assessment, for computation of compensation. It is the vehement contention of learned counsel that for appellant insurer that when there is no material evidence with regard to proof of income, the tribunal had fallen in error in assessing the income to be at 12,000 per month without any material basis. Whereas the tribunal ought to have taken the notional income chart for reference and awarded the income on the basis of the chart provided, which should have been at rupees 8,500 per month for the accident having occurred in the year 2014. Though at the first blush, the argument of the learned counsel for the appellant insurer looks very attractive and appealing, but I'm afraid the same cannot be sustained for the simple reason that on the basis of the material evidence produced, it is apparent on the face of the record that the claimant was a guest lecturer for a degree college and was working as a guest lecturer in two colleges simultaneously for 3 days in each of the colleges and securing income of 8,000 plus 6,000 respectively. Apart from what is stated that he was doing agriculture work. Full stop. Even if the agriculture work, no material has been produced by the claimant, and if income is not added to what is already produced at Exhibit P7 and P8, the income would come to 14,000 rupees per month, only as a guest lecturer. Full stop. Admittedly, there is no dispute that the claimant was working as a guest lecturer. In the evidence adduced by the insurance company, the appellant herein, it is not disputed and no question or suggestion has been put forth to the claimant PW1 that he was not working as a guest lecturer and that he is not qualified as a lecturer to secure such an income. In the absence of such contra material, the tribunal was left with no other alternative but to accept Exhibit P7 and P8. No doubt, the claimant does not examine the author of Exhibit P7 and P8 to establish and prove Exhibit P7 and P8. However, in the present case on hand, being a compensation, a claim for compensation for the injuries sustained in the motor vehicle accident, it's a right law that this legislation of the motor vehicles legislation is a beneficial legislation which is made for the welfare of the persons having suffered in the injuries in the course of accident. The benefit of doubt will always have to go in favor of the injured victim. Full stop. If a person has to be a guest lecturer in a government, in any of the colleges, he should have at least been completed his post-graduation degree to become a lecturer in a degree college. Hence, it can be inferred that the claimant was qualified and a postgraduate by profession, by education. Full stop. And Exhibit P7 and P8 would go to show that he was earning about 14,000 rupees per month merely as a guest lecturer. The tribunal, though has not taken the entire amount, has assessed the income to be at 12,000 rupees per month. Coming to the aspect of considering the notional income chart for assessing the income when there being no proof of income, it is not in dispute that when there is absolutely no proof of income produced by the claimant, then the courts will have to rely upon the notional income chart prepared by the Legal Services Authority as a guesswork to assess the income of the claimant. In the present case on hand, when admittedly the claimant is a postgraduate and a lecturer in a degree college, he cannot be relegated to a level of coolie or an unskilled worker to assess to rely on the notional income chart for assessing the income. The tribunal has rightly considered this Exhibit P7 and P8 and the oral and documentary evidence and assessed the income to be rupees 12,000 per month, considering the avocation and education of the claimant. I do not find any legal infraction or illegality in the tribunal arriving or assessing the income at 12,000 for a postgraduate educated person who's teaching in a degree college as a guest lecturer. Full stop. Next paragraph. The claimant has got examined PW2, doctor as PW2, who has deposed before the court and has stated that the claimant has sustained injuries to his person and body where he has sustained 26% permanent physical disability. The necessary documents to that effect are produced and exhibited. On the basis of these medical records, the tribunal has assessed the disability to the whole body at 9%. Which I do not legal infirmity or infraction, as the tribunal has relied on the basis of the expert opinion expressed by the doctor, namely PW2. Full stop. What is the age? There is no difference. Allah? The claimant was aged 26 years as on date of the accident, and accordingly the tribunal has taken the appropriate multiplier of 17, which is as per the judgment of the Honorable Apex Court in the case of Sarla Verma versus Delhi Transport Corporation. This also does not call for interference. Under the other heads, the tribunal has awarded for the loss of income during the laid up period to be 36,000 at the income as assessed at 12,000 per month, which also does not call for any interference. The tribunal has also awarded rupees 15,000 under the head travel expenses and special diet, which also does not call for interference at the hands of this court. Medical expenses ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
81,000.
81,000. The tribunal has, on the basis of the medical records produced at exhibits P9 to P14, awarded rupees 81,000 as medical expenses on the bill, which also does not call for interference by this court. Full stop. The other point seriously canvassed and urged by the learned counsel appearing for the appellant insurer is the interest awarded by the tribunal to be on the higher side at 9%. Learned counsel for the appellant has relied on the judgment of this division bench of this court in MFA 5896 of 2018, wherein the division bench of this court has considered the aspect of awarding of interest in a motor vehicles case and held that the interest will have to be considered on the basis of section 34 of CPC and awarded, reduce the interest from 8% to 6% in the set. I am in agreement with the contention put forth by learned counsel for the appellant insurer that the interest awarded by the tribunal is on the higher side and the same requires to be reduced to 6% as against 9% awarded by the tribunal. Full stop. In view of the discussions made above and on the basis of the submissions of contentions of the learned counsel for both the parties, I pass the following order. So only the interest gets down, sir, Mr. Venkatesh.
Sorry, Swami. Right, Swami.
The appeal is partly allowed. The compensation awarded by the tribunal at rupees 3,99,320 is affirmed. Second point, the interest awarded at 9% is toned down to 6% from the petition till date of payment. ನೀವು ಫುಲ್ ಅಮೌಂಟ್ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಸ್ಟೇ ತಗೊಂಡು ಅರ್ಧ ಕಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ, ಮಿಕ್ಕಿದ್ದು ಕಟ್ತೀನಿ ಸ್ವಾಮಿ. ನಾನು ಏನ್
The balance amount of compensation shall be paid by the appellant insurer within a period of
4 weeks, my lord.
4 weeks from the date of receipt of certified copy of this order, as 50% of the amount has already been deposited at the earlier before this court. The amount, whatever amount in deposit il madidira, the amount in deposit before this court shall be transmitted to the concerned tribunal forthwith. Yes.
Amount in deposit may be transmitted to MAC. I have deposited.
You went offline.
Oh,
yes.
no problem with that. Sorry, my lord.
Ravi Shankar for order.
Eli Ravi Shankar, release this matter after 2 weeks. Next.
58.
58. Ravindranath. What is this matter? Award, only that much. What do you say?
ಏನಾಗಿದೆ is continued job. ಈ ಬದಲಿ ಕೆಲಸ ಕೊಟ್ಟು ಏನ್ ಕೆಲಸ ಬಂದ ಮಾರ್ಗದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಟೀಚರ್ ವಾಸ್ ಸಾಮಾನ್ಯ ಕೊಟ್ಟಿದ್ದು 1,29,000
Does not call for any interference. No enhancement.
The amenity set only. Is not entitled because by submission is not. Loss of teacher earning kotte 1,20,000 kotte. In spite of continuing his job, is admitted in cross examination.
We'll do one thing. We'll have this matter on Monday. All right. At request of Learned Counsel for the appellant, released on 28th. All right, we'll consider it. Next. Kodi. End of the list, Kodima. You are there. Final hearing, yaar. Yaro? Injury case. So you're seeking enhancement. Mr. Krishna Swami is seeking reduction. Liability. Mr. Krishna Swami, are you disputing liability or only quantum?
My lord, both, my lord. Liability to pay compensation.
Owner, where is the owner? All right. Now that he is disputing the liability, you want to fasten it on the owner.
Yes, my lord. That has to be done.
Or you're seeking saying contributory negligence on the
no contributory.
Payment.
In fact, he traveled in a goods carriage. He contends that he was working as a manager in petrol bunk.
Then owner is required.
Owner is required, my lord. Without which, and added to that one, I had suggested to my learned friend. In fact, a major link is missing. That is, he was employed and he was traveling in the lorry as an authorized person, as being the owner of the goods. That is not forthcoming. Nowhere it is stated. Some evidence is required. In fact, I suggested to my learned friend. Varadaraj had suggested, he once agreed, it was argued also before the court.
All right. So you're suggesting that this should be sent back.
In fact, if it is sent back, that would help both the parties. In fact, even it would help the claimants to get just compensation. Should he not get it?
Take another 4 to 5 years.
No. You are a claimant, sir.
Claimant, 4 lakhs and not liberal has awarded.
You're happy with that?
Yes, I'm happy. You also have filed an appeal. I'm happy with that amount. My letter friend continues that I'm glad. Therefore, insurance company is not liable to pay. It's not judgment of installment report. Subsequent other judgment in view of 1994 amendment.
Sir, whether the liability is on the insurer or on the owner, you are going to get compensation.
But the amount, then once it's demanded, it has to be set aside the entire award and demand. Debited to the tribunal. Decide the matter in the council law. Till then, what about my livelihood right? I'm facing financial situation not. Or late financial situation not. This amount, what about this amount awarded by the tribunal? I don't press my appeal. I will argue the matter as proposed. My letter friend's appeal is concerned. My letter friend is only harping upon only a single issue, that is a gratuitous passenger, but he has not proved that fact. He has only taken up such a contention. The finding of tribunal is that he is not a gratuitous passenger, he is an employee.
All right. Now, even if it goes back, there may be chances that your compensation may get enhanced. You're sure it is not going to get enhanced? Adil Ray, maybe we will. Mr. Ashwat Narayan Reddy, this court has not expressed any opinion that it is not going to be enhanced or it is in favor of Krishna Swami. What Mr. Krishna Swami says is that it is going to be in the benefit of both parties if the matter is going to be sent back for evidence on that directed to passenger or. All right, then you argue on merits of the matter. You are ready today?
Yes, I am ready.
You are also ready today? You will be able to finish it? Afternoon. What are the other matters we have? Monday. What about Monday, Mr. Krishnasamy?
Monday is ideal for me also. No problem.
All
I
right.
leave it.
So you can proceed with arguments and we'll dispose of them. At request of Land Council for respondent number 1, relist this matter on 21st. 21st you want is okay?
Okay, man.
Yes. Relist on 21st.
65 adjourned, number 66.
Ankegowda. Notice to R1 dispense, Vijay Kumar R2, Pradeep R2. Claimant's appeal? Where is Pradeep?
Yes, my lord, I am prepared, the respondent.
Is there anything in the matter for enhancement?
My lord, the contributory negligence has fixed against the injured at 15%.
On ground of what?
The contention of the claimant that, my lord, he was a pillion rider. But during the course of cross-examination and in the medical evidence, it shows that, my lord, he only riding the motorcycle as on the date of accident. Para 26, my lord. Para 21 is relevant, my lordship. Para 21. The tribunal consistently coming to the conclusion that he himself is riding the motorcycle.
All right.
15% negligence has been fixed against him, my lord.
No, if he himself was riding the motorcycle, where is the negligence?
No, my lord, he is also contributed to an extent of 15%.
Jesus, my lord, part of the driver of the car, but the FIR and charges, my lord, very against the driver of the car.
Mr. Pradeep.
Please, my lord.
You are now attributing negligence to the claimant who was riding a motorcycle.
Motorcycle.
So what has the tribunal done?
Tribunal has ordered for 15% against the injured and 85% against the insurer of the car, my lord.
Correct. So now that is in challenge before this court. He says there's no negligence.
Regarding that, my lord, para 20 and 21 is very relevant, my lord.
Para 20 says what?
Because of filing of charge sheet itself is not a conclusive factor, my lord. The sketch which sketch has not been produced by the petitioner to show that exactly.
What is the contributory negligence as against the rider of the bike, who the claimant? Claimant, according to you, is a pillion or rider?
No, my lord. He is not a pillion rider. He is a rider of the motorcycle. RW1, who has been examined before the court, who is a medical officer. Before him, my lord, he has stated that he was a rider of the motorcycle. To establish that, my lord, we have examined the RW1, who has categorically stated that he himself has given a statement before the hospital authorities and saying that he is a rider of the motorcycle.
All right.
He has implicated on another rider, my lord, saying that he is a pillion rider.
All right.
The tribunal coming to the conclusion that, my lord, he is also a negligence in causing accident.
How? Merely because he was a rider?
When he was, please, my lord, he was a rider of the motorcycle who did not possess driving license as on the date of accident. The cross-examination may kindly be seen, my lord.
It is your case that he did not have driving license?
Please, my lord. He himself is the owner of the vehicle also.
All right. Now, whether merely because he doesn't have a driving license, where is the contributory negligence?
Contributory negligence only because of that. Allah Swami, our sketch produced modilla, they have not established, they have not proved. There is entirely negligence on the part of the offending vehicle.
Mr. Counsel, is there any case filed against the claimant?
No, my lord. Charge sheet filed against the insurer of the car only, my lord. But
Right.
mere filing of charge sheet itself is not a decisive factor.
All right, correct, that's right. But what is the contrary material that you have placed before the court to show that there is contributory negligence on behalf of the claimant?
ಅದನ್ನ ಮರೆ ಮಾಚ ಉದ್ದೇಶದಿಂದನೇ ಅವ್ರು ಪಿಲಿಯನ್ ರೈಡರ್ ಅಂತ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ರೈಡರ್
Even if he has said so,
please, my lord.
even if he has said so, now the law is established with regard to driving, there being no even driving license. Even if he doesn't have a driving license,
please,
that by itself cannot attribute contributory negligence to the claimant unless you show that he has contributed to the occurrence of the accident. That is a judgment of the apex court.
ಹೌದು ಸ್ವಾಮಿ, ನೋಡಿದ್ದೀನಿ. ಬಟ್ ಇದರಲ್ಲಿ ಅವರು 166 ಅಲ್ಲಿ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಹಾಕಿದಾಗ ಅವ್ರು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ. ಫೈಲಿಂಗ್ ಆಫ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇಟ್ಸೆಲ್ಫ್ ಇಸ್ ನಾಟ್ ಎ ಪ್ರೂಫ್ ಆಫ್ ಎವಿಡೆನ್ಸ್.
No, it is only preponderance of probability and not beyond reasonable doubt.
ಸ್ಕೆಚ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕಾಯ್ತು, ಮಾಡಿಲ್ಲ.
So the preponderance of probability and what is loaded in his favor is the charge sheet and the FIR and all police records.
ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್, ಸಮ್ ಆಫ್ ದ ರೆಕಾರ್ಡ್ಸ್ ಹಸ್ ನಾಟ್ ಬೀನ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. ಸ್ಕೆಚ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕಾಯ್ತು, ಅದು ಮಾಡಿಲ್ಲ. ಸ್ಪಾಟ್ ಸ್ಕೆಚ್ ನ ಸ್ಪಾಟ್ ಆಫ್ ದ ಆಕ್ಸಿಡೆಂಟ್ ಎಲ್ಲಾಗಿತ್ತು, ಎಷ್ಟು ವಿಡ್ತ್ ಆಫ್ ದ ರೋಡ್, ಅದೆಲ್ಲ ನೋಡ್ಬೇಕಿತ್ತು.
All right, we'll consider this. We'll have this matter on 22nd.
Please, please, man.
Leave it on 22nd. Let's call this matter on 22nd. That is the only point involved.
Please.
That is the only point.
ಹೌದು ಹೌದು ಸರ್.
ಕೊಡಿ. Yes, Ravi Shankar. ECA. What are you seeking in this?
He's not an employee of Discom. The policy is husband compensation policy.
Delay ideyalla. What it is delay? Will issue notice.
Yeah.
How?
Because you already deposited a job.
You deposited the entire amount.
Otherwise, you can't call the ECA. Partial reservation. Otherwise, you cannot move the entire amount has to be deposited.
Kodima.
Report. Produce the receipt.
Huh?
31 of the certificate of deposit.
31 of the ECA.
ECA. Certificate of deposit.
(1995) amendment.
Provided further that no appeal by an employer. The clause
Yes, yes, I got that. So you have deposited the entire amount. No, no.
certificate of community. Original.
Again, execution ಹಾಕಿದ್ದಾರೆ.
Without execution also they have issued because not required them. So normally that's we can issue.
No, no, no. The apprehension of your
Because I have a 24 to you can withdraw the amount anytime. Because there is no question of staying behind without that. Otherwise they will issue the amount from the commission.
what are you challenging here?
This one is employment, another is shift interest, and this is not the basic policy.
So your case is that he is not an employee.
Subcontractors or whatever, they are not issued the subcontractors. Only the skilled labor we are issued for 3 members. That's why NESCOM. The amount will be kept in the FD.
Recording. Heard. Lord Counsel Sri Ravi Shankar Sihar on behalf of the appellant insurer. Issue notice to the respondents. 1 to 8, huh?
Also,
Notice to respondents 1 to 8. On the main as well as on IA1 of 2022. IA1 and IA2. Full stop. %80 is fixed on you.
it's the 677 is the order. That's why the amount has been deferred.
What about the remaining amount?
If you apply for the rent order,
ಕೊಟ್ಟಿದ್ದಾರಾ?
the rent order, that's why commission comes to total 677. The basic of the
This appeal is premised on the ground that whether there was a relationship of employer and employee, whereby the insurer would be liable to indemnify the employer. Substantial question of law is raised by the appellant insurer. It is submitted that the appellant insurer, in pursuant to the order of the commissioner, MACT and commissioner, pursuant to the orders of the commissioner, has deposited the entire amount as per the impugned judgment, and he has produced the certificate. He has produced the memo of deposit for having deposited 6,77,760 dated 17/2/2022 before the commissioner. In view of the fact that he is challenging the impugned order with regard to the relationship being denied between the petitioner and the, who's that respondent?
Respondent 3 to 6 years.
Respondent 3 to 8. He seeks for an order interim order of stay, full stop. Hence, I deem it appropriate to issue notice to the respondents. Orders on IA 3 of 2022. There shall be stay of judgment
Where is
your application? What is your application? Without permission. Stay of operation and enforcement of the judgment and award in ECA number 4 of 2015, dated 19/11/2019, passed by the additional senior civil judge and MACT, Madhugiri, pending this Madhugiri. Yes, stop. The amount in deposit made by the appellant insurer shall be kept in a fixed deposit. Fixed deposit in a nationalized bank for a period of 6 months or until earlier disposed of by this court. The remaining amount has been ordered to be paid by the owner. Or Kotidara. Correct, because it is disposed of. Now, note the yesterday. I think it was disposed of in admission stage. Correct. So there is no substantial question of law framed by this court. So I have framed substantial question of law and held it in the decided both. Correct. No, I was correcting the draft. At that time, I realized there is a question of law in this. Then I framed the question of law and held it. Thank you for assisting. No, sometimes even in the busy work, what we do, it gets ignored. we also think that it is done. And I realized that it was, I also said that since it's disposed of at the admission stage, framed ಮಾಡಿದ್ದು. ಯಾವುದು ಅರ್ಜುನ್ ಆಗಿ No, if there is no dispute, we can dispose it down.
You can calculate and give it to me. But in every case, you actually have to see the document. Otherwise, how can you? Notice what will you?
In which matter? 45?
45.
Or idralla? Registry to secure TCR matter. Any other matter? Yes, sir.
Court officer, madam. Court officer. Court officer.
Sir?
Serial number 61 reach agilla alla madam.
Serial number?
61.
Sir, 61 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಸರ್.
ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
2 weeks.
Okay. Thank you, madam.